Pette-Lapelle, Mr. Greffier, s'il vous plaît.
Monsieur le sénateur Routier.
Présent.
Monsieur le sénateur Joseph. Monsieur le sénateur McLean. Monsieur le sénateur Gold.
Présent.
Monsieur le sénateur Farnham. Monsieur le sénateur Balash.
Présent.
Monsieur le sénateur Green.
Présent.
Madame le sénateur Ferguson.
Présente.
Monsieur le connétable de Saint-Helier. Monsieur le connétable de Saint-Clément.
Présent.
Monsieur le connétable de Saint-Pierre.
Présent.
Madame le connétable de Saint-Laurent. Madame le connétable de Sainte-Marie. Monsieur le connétable de Saint-Roch.
Présent.
Monsieur le connétable de Saint-Brelade. Monsieur le connétable de Saint-Martin.
Présent.
Madame le connétable de Saint-Sauveur. Monsieur le connétable de Gruville.
Présent.
Monsieur le connétable de Saint-Jean.
Présent.
Monsieur le connétable de la Trinité. Madame le député Martin.
Présente.
Monsieur le député Sullivan. Madame le député de Gruville.
Présente.
Madame le député Hilton.
Présente.
Monsieur le député Lefondre.
Présent.
Madame le député de la Trinité. Monsieur le député Lewis de Saint-Sauveur.
Présent.
Monsieur le député Tadier. Monsieur le député Noel. Madame le député de Saint-Jean. Monsieur le député Higgins.
Présent.
Monsieur le député Masson.
Présent.
Madame le député Pennell.
Présente.
Monsieur le député de Saint-Martin.
Présent.
Monsieur le député Bryans.
Présent.
Madame le député de Saint-Pierre.
Présente.
Monsieur le député Rondel.
Présent.
Monsieur le député Mezek. Monsieur le député Lewis de Saint-Helier.
Présent.
Monsieur le député de Saint-Maur.
Présent.
Madame le député Dublé.
Présente.
Monsieur le député Labby. Monsieur le député Wickham.
Présent.
Monsieur le député Bree.
Présent.
Monsieur le député Norton. Monsieur le député MacDonald.
Présent.
Monsieur le député de Sainte-Marie.
Présent.
Monsieur le député Truscott. Monsieur le député McClinton.
Monsieur le doyen.
Notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et les puissances de la terre pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, donner le cœur et les affections de tous ceux qui la composent, et de les conduire tellement toi-même par ton Saint-Esprit, que toutes leurs délibérations étant accompagnées de ta bénédiction. Voyons si au bien et au soulagement du peuple qu'il t'a plu de commettre à le soin. Quand nous t'en prions, au nom et par le mérite de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite dans la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonne nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous induis point en tentation, mais délivre-nous du mal. Car à toi la reine, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le sénateur Joseph.
De feu.
Monsieur le sénateur McLean.
De feu. Oh. Tu l'avais.
Monsieur le sénateur Farnham.
Présent.
Monsieur le connétable de Saint-Helier. Madame le connétable de Sainte-Marie.
Malade.
Je jure que Madame le connétable de Sainte-Marie est tellement disposée qu'on ne peut pas assister à tâche d'exposer sa santé. Monsieur le connétable de Saint-Brelade.
Présent.
Monsieur le député Sullivan. Présent. Monsieur le député Mezek. Présent. Monsieur le député Norton.
Présent.
Monsieur le député McClinton.
Malade.
Pouvez-vous que Monsieur le député McClinton est tellement disposé qu'il n'est pas prêt à assister au tas en exposé sa santé?
Les États sont constitués.
Sir, I just declare that I'll need to leave the chamber around about 10:15 this morning to attend a hospital appointment.
Sir, just to advise that I have 2 medical appointments today, one late morning, one mid-afternoon, which I hope won't take up too much time. I'll be back as soon as I can.
Deputy. As will be apparent from that welcome, Deputy, it's a tribute to you that you're here. Thank you. We return to the debate and second reading on P91. The first thing I wish to raise with the Assembly is that there have been a number of amendments which have been lodged late under Standing Order 26, paragraph 7. We can proceed to permit the amendments to be debated. I should be grateful if I could receive a proposition to permit late.
Happy to propose that, sir.
Is that seconded? Does any member wish to speak on that? Then all those in favour of late tabling kindly show. Those against? Very well. That means that we will be debating all the amendments which have been tabled late to P91. Deputy Chief Minister, you wish to propose Article 1?
Yes, please, sir. As you say, sir, we're returning to the Marriage and Civil Status Jersey Law 2001. Principles were accepted by the Assembly in November. My first task is just to propose Article 1, which does no more than set out the references to the 2001 law, being the Marriage and Civil Status Jersey Law 2001. So I propose the article.
Seconded?
Yes, sir.
Any member wish to speak? All those in favour of adopting the article kindly show. Those against, the article is adopted. Deputy Chief Minister, you wish to propose Article 2?
Thanks, sir. I propose Article 2 of P91 2017 in the second reading. Article 2 substitutes Parts 1 and 2 of the current 2001 law with a new Part 1, which includes new Articles 1 to 7, and a new Part 2, which includes new Articles 8 to 24G. So, as we know, the Corporate Services Scrutiny Panel have reviewed the proposed changes to the 2001 law and before us today, and there are a number of amendments to P91, some of which arise from the panel and some from myself. Before starting, I would like to thank the panel for its work. Whilst I do not agree with all their proposed amendments, legislative scrutiny provides a vital challenge, and we should all welcome those challenges. So I say thank you to the Chairman and his panel for the work that they have done. Before we get to those amendments and the debates that I'm sure will ensue, I'd like to set out for the Assembly the effects of the new Articles 1 to 24G that form Article 2 of P91 2017. So in doing so, I will try not to repeat all that I have previously said, but I do want to remind members of the key provisions of the amendment law. This includes, notably, that same-sex couples in Jersey will be able to express their love and their commitment to each other through marriage. All people will have more choice over where they get married, including being able to get married outside. They will have more choice over who marries them and more choice over the content of their wedding ceremony. It will be significantly easier for people to book their weddings and register their marriage. And importantly, we will have a law that provides better safeguards against sham and forced marriages. So I'd like to talk briefly about protections for religious officials and organisations. This Assembly has already agreed in principle that same-sex marriage should be introduced, subject to appropriate measures to protect the rights of religious organisations and officials who do not wish to solemnise the same-sex marriage. Article 2 provides those protections. A religious organisation or official cannot be compelled by any means to consent to any matters relating to same-sex marriage, whether that be consenting to the solemnisation of the same-sex marriage, or to a place of religious worship being used for same-sex marriage, or to attend or apply for or provide certificates in any matter relating to same-sex marriage. And even where the religious organisation consents, their officials cannot be compelled, and as set out in Amendment to P91, which we'll be shortly considering, a person cannot be forced to refrain from withdrawing consent previously given. Additional protections are also provided in relation to Anglican marriage. The common law duty of clergymen to solemnise marriage does not extend to same-sex couples, nor does the common law right of a person to have their marriage solemnised by the Anglican clergy. In addition, a usual place of worship, according to the right of the Church of England, cannot be authorised for same-sex marriage. We have previously discussed these protections, and they accord with those in UK legislation and are commonly referred to as the quadruple lock. It is important to note, however, none of these protections prevent religious organisations and officials from solemnising a same-sex marriage if they want to. So I'd like to talk briefly about sham or forced marriage. As previously discussed, it is possible at present for a person to organise a marriage in Jersey without the knowledge or consent of their partner, who may know nothing about it until they are standing in front of the civil marriage celebrant being asked to make legally binding vows. So it may be romantic, but it's not right. Such weddings will not be allowed to take place under the amended law, which introduces a range of safeguards, unlike the current law, the current 2001 law. Both parties to the marriage will have to give notice. Both parties to the marriage will need to sign a declaration stating that they are free to marry. And both parties will need to present themselves to the Superintendent Registrar and complete a signature verifier form. The form will be issued to the marriage celebrant so that the celebrant can confirm that the people standing in front of them are the same people given permission to marry, the same people whose passports and visas and supporting documents which were inspected by the Superintendent Registrar. So Article 2 provides that non-residents getting married in Jersey must provide a certificate of freedom to marry, confirming that the marriage authority in their place of residence knows of no reason why they cannot get married. No one will be able to give notice to get married until the Superintendent Registrar knows that, and if required, has seen the visa and that it is in place. Once notice is given, it must be in the public domain for at least 25 days as opposed to the current 14 days. Enhanced safeguards include moving from handwritten to printed certificates and documents. I think that's a slight cause for regret, but we must protect important legal documents. The new streamlined process I'd like to briefly talk about now. The amended law makes it easier for couples to give notice online and to have their marriage registered. Couples are only required to visit the Superintendent Registrar once before the ceremony. They do not need to visit or collect documents from the parish registrar. So emergency marriage as well. The amended law makes enhanced provision where there is a risk of death, a person is housebound, or needs urgent medical attention. In these circumstances, the Superintendent Registrar can forego the usual checks and balances so that the couple can marry as soon as possible or in a place not approved for marriage. Further provision is made for those who, through illness or disability, cannot sign their names or make their mark. Emergency marriage is possible under the current 2001 law, but is via special permission of the Dean, so that excludes same-sex couples and those who do not want to marry under Anglican licence. Article 2 also provides that the Superintendent Registrar has the right to refuse to issue permission to marry or to delay issuing permission to marry if a person is not capable of consenting to marriage. So, if there is doubt whether they have the mental capacity to do so or if they are not sober enough at the time. Restrictions on marriage, sir. Restrictions on marriage are set out in the 2001 law. They are largely unchanged except to reflect the introduction of same-sex marriage. We have, however, introduced a power allowing us to increase the age of marriage by regulation. We have done this because the UNCRC is calling for a minimum age of 18 to protect child brides. Place of marriage, sir. Article 2 provides for an open-air marriage at any location deemed to be solemn and dignified by the constable. The minister will provide for an approval process by order which will broadly reflect the current processes familiar to constables. When the open-air location is in private ownership, the process of booking the wedding is straightforward. Where the location is public, such as a beach, the process may be more complex as multiple permissions may be required. For example, permission from the Economic Development, Tourism and Sport Minister under the Policing of Beaches law. We recognise the complexity, sir, and officers will be working to identify an appropriate and long-term solution. Open-air marriages, though, as I said when we did the principles, sir, brings a degree of buyer beware. Because if it rains, the couple will get wet, as they must marry at the location named on the notice to the marriage. This is in order that objectors may attend, sir. So a location that is approved for civil marriage is automatically approved for same-sex and opposite-sex marriage. A place of religious worship is only approved for same-sex marriage if the consent of the religious authority is provided. Religious marriages can take place in locations approved for civil marriages. For example, the Methodist minister may marry a couple on the beach, providing that the minister agrees to do so. So I'd like to talk briefly about celebrants. Under the 2001 law, civil marriages are solemnised by the Superintendent Registrar or deputies. Under the amended law, civil marriages will be solemnised by civil celebrants, individuals authorised by the Superintendent Registrar. A couple will be able to choose the celebrant who marries them. They will meet in advance and plan the ceremony. This is a contrast to the current law, where couples are simply allocated someone with no opportunity to build up a relationship. Humanist celebrants will be able to solemnise marriage in Jersey. They must be authorised to do so, thus ensuring that they have access to the information and support necessary to marry people in accordance with Jersey law as distinct from the UK law. This authorisation process will be described in order and will apply to all celebrants except Anglican officials who marry in Jersey. The panel proposes amending the relevant provision in P91 so that our primary law sets out a requirement for individuals who purport to represent certain groups such as humanists that they must provide evidence of their qualifications. And so we will be accepting that amendment. But we will also provide, by order, as we had intended to do, that the requirement goes beyond qualifications. It will require evidence of accreditation or membership of the organisation as relevant. So, talk briefly about the conversion of civil partnerships into marriage. Article 2 provides for couples who are in civil partnership to convert that civil partnership into marriage. Where they do so, their marriage will have subsisted since the day of the civil partnership, not the day it was converted to marriage. Conversion can be quick. It's an administrative process which simply involves the signing of forms, or if the couple want it to be, it can be a full-blown cause for celebration and another wedding ceremony. So Article 2 brings forward significant changes to our existing marriage and civil status law, changes that I believe benefit our community. I have set those out in the broadest terms, so I propose Article 2.
Proposition seconded.
Yes, sir.
Well, we now come to the amendments to this article.
Sorry, sir. Could we raise the defo on Senator McLean, please?
Does the defo be raised on Senator McLean? The defo is raised. We come to the amendments to this article, which have been proposed in first of all by the Chief Minister. If I may say to members, many of these amendments seem to me to be completely non-controversial, and I would hope to take them fairly swiftly because there are some matters of principle to be debated. And if I've misread that, obviously it will become plain during the term of the debate. It will take longer. But at any rate, now, Deputy Chief Minister, you wish to propose the amendments to P91 lodged on the 31st of October, 30th of October last year, except Amendment number 6.
That's correct, sir. Thank you. So this amendment includes 23 separate amendments, and as you say, sir, we will be proposing it in its entirety, except for Amendment 6. Just to explain, sir, Amendment 6 brings forward changes to the new Article 7, which forms part of Article 2 of P91 2017. And as the proposed new Article 7 falls within the proposed panel amendments, now is not the time to debate Amendment 6. We may, however, need to return to it at a later point in the proceedings. As stated by both the Chief Minister and myself, we did push for P91 to be lodged early in October 2017. And we did so because we were concerned that same-sex couples were waiting too long to get married. In making that decision, we recognised that we would have to amend post-lodging. This does not mean that the policies that underpin P91 have been poorly considered. I can assure members that they have been given the fullest consideration. They have been extensively consulted on, albeit primarily at the principal stage as opposed to the consultation on the draft law. Our push for a timely lodging simply means that the process of final checks for clarity of language and other associated matters was curtailed. The great majority of the changes set out in this amendment are very minor. They address typos and errors of that sort, sir. They serve to clarify matters of language or provide additional clarity to the effect of the provisions. The panel themselves, sir, the scrutiny panel, have also identified a number of minor changes as set out in their amendment. So excluding Amendment 6, which we are not dealing with at this point, only 7 of the 23 amendments have any material effect on the provisions of P91. And in brief, this includes Amendment 5, which clarifies that a religious official authorised under the current 2001 law will automatically be authorised to solemnise marriage under the new law. But they may choose whether or not this includes same-sex or marriage in locations other than their usual places of worship. Amendment 14 clarifies that locations currently approved for civil weddings will continue to be approved up until the point that their current approval expires. They will automatically be approved for both opposite-sex and same-sex marriage. Amendment 17 confirms that the Superintendent Registrar and the Deputy Registrars are employees of the States of Jersey as opposed to the State's Employment Board. This amendment simply reflects the provisions under the States of Jersey Employee (Jersey Law 2005. Furthermore, the existing delegates who solemnise marriage under the current law can, if they wish, become Assistant Deputy Registrars. This will help to ensure that there are sufficient numbers of people to solemnise civil marriage in Jersey, whilst the new market for independent celebrates is developed. Amendment 18 is brought forward in response to consultation with the Committee to Conitab, and it provides that the Conitab will appoint the parish registrar, notifying the parish assembly in advance, and that the parish registrar will be resident in the parish unless there is a vacancy, in which case the Conitab may appoint the superintendent registrar or parish employee or registrar from another parish. The purpose of this provision is to allow for parish registration service to function in emergency circumstances such as pandemic flu. Constables in appointing parish registrars will have regard to the role description published by the superintendent registrar. This amendment, when taken alongside other provisions set out in P91, will ensure that each constable will have the flexibility to decide on what is right for their parish with regard to their parish registrar. Further to this amendment, Amendment 19 provides that a notice of office is displayed at the premises used by the parish registrar as opposed to at the registrar's home in the event that they do not operate from home. Amendment 20 makes it an offence for a person to knowingly and voluntarily make a false declaration or provide false information when applying for a person to be approved as a marriage celebrant, or for a location to be approved for a solemnisation of marriage. And finally, sir, Amendment 24 brings forward changes to the Gender Recognition (Jersey Law 2010. It allows the court to determine what evidence it will accept when considering an application for a gender recognition certificate. The law will no longer require applicants to provide a full UK gender recognition certificate. Currently, in order for a person to get a full UK certificate, they must have their ex-spouse's consent. No consent, no certificate. Thus, in the UK, a husband or wife can veto their spouse's right to change gender. This Assembly agreed in principle, sir, in 2015, that there should be no spousal veto in Jersey. It is contradictory to provide a gender recognition veto in a system which otherwise recognises that we are free to act regardless of what our spouses wish, how our spouses wish us to act. We are free to live apart. We are free to apply for divorce. We are free to borrow money, and so forth. So I think I've covered the main points, therefore I propose Amendment 1, excluding the Sixth Amendment.
Sir, could I seek your guidance on something before we open the debate? This is a future interest. I'm not quite sure where I stand on this, so I wanted to seek your guidance as to whether I need to withdraw. Because of my commitment to humanism, I've been asked to embark upon the training to become a humanist celebrant, and I have agreed to this. So I wanted to know whether that future interest would require me to withdraw from the debate.
Deputy, I regard it as not being an immediate financial interest, and therefore you may stay, and you've declared the interest, so members will know.
Sir, can I also ask your guidance? And I apologise if I'm totally confused, because I'm looking at this legislation, and I've just been told by the proposer to ignore Part 6, page 73, Article 2, which is the controversial part. So I've got I just need to for you, sir, to explain, because I don't think I've ever seen a piece of legislation where I've been told we can discuss this later. Sorry, sir. Thank you.
Deputy, the way the running order is going is based on the proposition that the proposer of this amendment could, if he wished, ask the Assembly to deal with each amendment separately. Now, that would be a cumbersome way of doing it when so many of the amendments are absolutely straightforward and non-controversial. And so what he's doing is proposing all the ones which he believes to be non-controversial, but leaving over the one which clearly is controversial, which will come up for debate later on. If during the course of the debate on these ones which are thought to be not controversial, it's apparent that some are, then no doubt the proposer can be asked, he doesn't have to agree, it's his proposition, but he can be asked to agree a separate vote on those particular amendments.
Sorry, sir, and I totally respect your, and I've asked for your guidance, but when I see this in the first legislation, so can I get this right, sir? It's the proposer who's asking we don't discuss it. So when do we come to the vote? Or could the proposer say, it's in this is the first time we see it, and we discuss the main issue, which is the amendment is Article 6, Part 6 rather, now. So what happens when we come to the vote? Because are we not going to vote on that part? I just have to be clear.
I've
not seen this before.
The numbering is awfully difficult, isn't it? When you say Part 6, the controversial part, as I understand it, is Paragraph 6 of the amendment, which is Article 7 of the law as amended. It would be if it's adopted, and we will come to a debate and vote on that later on today. This amendment is dealing with all the other amendments in this document, but not that what I call Paragraph 6, Article 7, which we will deal with later.
Well, I'm sorry to labour the point, but why is it in there then if we're dealing with it in a different part of the amendment? I'm very confused. I do not want to, as you said, sir, it's not controversial. I see something written in a proposition that we're going to deal with in another proposition, and I've never seen this in. I need to know that I'm not having the wool pulled over my eyes, sir. Thank you.
Deputy, you're not having the wool pulled. We need to know what Article 7 is going to look like, and we won't know that until we've debated the amendments, and that's why this part is going to be debated later on.
So I don't know if I can help the Deputy, sir, because it is quite...
It's a ruling from the Chair.
Sorry, sir.
So are these amendments seconded?
Yes, sir, thank you.
Does any member wish to speak on any of these amendments? Constable St. John.
It's just a clarification, sir, on the first page. Oh, sorry. A clarification on the first order. It says Part 2 in the substituted article after definition licence. A parish assembly means in relation to a parish the assembly of principals and officers of the parish. I'm just concerned that a parish assembly actually is principals and electors. I understand it has been looked at, but I would like a definitive answer, please.
That may be a matter for the Solicitor General later on. Does any other member wish to speak? Deputy Mazzei.
Thank you, sir, and I apologise that I might be adding some confusion to this because I've only recently read the line on the guidance that we've been given about the format for this debate. Page, if I can find it, is page 17. It says, note there can be only one vote on the article brackets as amended. It is not possible at this stage to have separate votes on the articles inserted by Article 2. It may well be the case that many of the paragraphs that are inserted by Article 2 are non-controversial. I have a particular angle on articles, obviously Article 7, that's going to be the controversial one, but Articles 15 and 23 are articles that I would like to address and, if possible, would like to vote on separately. And I'm not quite sure how that features in this, whether that's possible or if it's possible, when that can happen.
Because of the way the standing orders are drafted and the way the amendment to the law is drafted, one can only take the full articles. One can only vote on the full articles at a time. So I've just lost my copy of it. So that if you look to the main proposition, the amendment number 4, draft law, Article 1, which we have voted on, Article 2 we're going to come on to vote on at the end, is one article, but it does introduce a whole number of different articles in the substantive law, which is the Marriage and Civil Status Law 2001. So the vote, when it comes to it, on whatever Article 2 of this amendment law looks like, will be one vote. There'll be lots of votes before we get to that point, but there can only be one vote on the whole of Article 2. Now, you say you're concerned by Article 15 and 23. There are some amendments to those articles which we will debate and vote on separately, but when it comes to having finalised those amendments, so we know what those articles look like, it will still be a vote of either you take the whole Article 2 of this draft amendment law or you don't. That will be the position.
Thank you, sir. That's very helpful. I suppose the only further question to that is, when is the most appropriate time to raise objections to those articles? Is that... okay, Article 7, there's going to be debates on amendments, so I presume we can raise objections during those debates. Article 23, is there amendments to that one, I think, as well?
There are some amendments.
Yeah, so I can raise objections in that debate, presumably. But what about Article 15? I want to find the most appropriate time to do so.
Article 15 is also the subject of some amendments now. One amendment now for the specified is changed for solemnised. I mean, that maybe you won't find much to talk about on that. But in relation to the others, you can certainly speak to the amendments, but you can have the opportunity of speaking to any fundamental issues you have with the drafting when we return to the principles after all the amendments have been dealt with. Is that right? Deputy Tabley,
so yeah, just to double check. So if once the debate has been had on the Corporate Services Amendment, the substantive amendment which relates to Article 7 of this Article 2, will I still be able to raise objections which don't arise from the Corporate Service Panel's amendment after that debate that relates to Article 7?
Yes, because if you wish to vote against Article 2, whatever it looks like by the time we finished, then you have a chance to speak.
That helps. Thank you.
Right. So with that in mind, does anybody wish to speak on this amendment? Very well, Deputy Chief Minister, do you wish to reply to the Constable of St John, or do you wish to ask the Solicitor?
No, sir. I think the Solicitor General is probably best placed to answer it. But we did ask the question last night and received assurance from the Solicitor General. But I think it's probably better he shares it with the Assembly.
Solicitor
General? So the drafting of Parish Assembly, which is sought to be inserted by the Chief Minister's amendment, is correct, sir, in that it refers to two things. There's principles, and the meaning of principles was expanded by an amendment to the rates law in 1975, such that it's expanded to include a person who resides in the parish and is registered for the parish as an elector in parish elections. So effectively a principal is an elector. And then the second part of the definition, sir, refers to officers. And the reason for that, sir, is that officers are listed out in, I think it's Article 2 of the 1804 Loi. And there is a, albeit small, possibility that an officer may not reside or be registered in the parish for elections because, for example, certain members of the Honorary Police have recently been allowed to carry on as members of the Honorary Police, albeit that they have moved outside the parish. So that's the reason for the two parts of the definition. And so I confirm that definition is appropriate and should be inserted into the law.
Constable, that answers your question. You're happy with that? Good. Very well. All members in favour of adopting these amendments, kindly show.
Appel, sir.
The appel is called for. Invite members to return to their seats. The vote is on all of the proposed amendments to his own proposition lodged by the Chief Minister on the 30th of October, except paragraph 6 on page 3, which relates to Article 7, paragraph 2 of the substantive law. And I invite the greffier to open the voting. All members have had the opportunity of voting. Ask the greffier to close the voting. And I can announce that the amendments have been adopted, 44 votes in favour and no votes against. That then takes us on, in the running order, to page 8. And we turn now to the amendment of the Chairman of the Corporate Services Panel, who will be proposing the second amendment to P91, except for Amendment 7, which we're going to come to later. I'll ask the greffier to read the amendment. Yes. I understand the Chairman wants to propose it as amended by paragraph A of the second amendment. Do members have any objection to that? Then please, greffier, would you read it as amended?
The amendment is as set out on the amendment paper.
Well, let's hope everyone has a copy. Chairman.
Thank you, sir. One should never start with an apology, but I do apologise on this speech because it is going to be longish, because we might get a feeling for it. There are rather a lot of amendments involved, and this is not focusing on the tolerance clause per se, as people might like to call it. I also don't want to muddy the waters particularly, sir, but in relation to the queries from Deputy Mezek and Deputy Tadier, if I don't know if this helps, we vote on Article 2, or what's been referred to as Article 2, which is basically most of what we would call articles, on one vote. And therefore, if Deputy Mezek, for example, has a concern around the quadruple lock, which is 7, 15 and 23, that will be encapsulated as well with Article 2, which introduces same-sex marriage. So therefore, one won't be able to separate the two. It's either his judgment to make a vote for that, because he wants to support same-sex marriage, as do I, or whether he wants to vote against it because he objects to the quadruple lock. Right. I think perhaps also, well, I'll get to that, sir. But anyway, on the 14th November, sir, last year, we called in the draft law for legislative scrutiny in light of the breadth and depth of the proposed changes. And the aim of our review was to examine how effectively the draft law implements the decisions of the States Assembly. It was not to reopen the debate on same-sex marriage, and this has remained the case throughout the review. So during the review, we've tried to do a detailed line-by-line analysis of the draft law. We issued a call for evidence and received 50 written submissions. We held 7 public evidence sessions with a range of stakeholders, including the Superintendent Registrar, the Comité de Connotab, religious organisations, equality charities, ministers and their officials. And I would like to thank those who contributed to our review, including the work that the Chief Minister, the Deputy Chief Minister and his staff have done to try and address some of our concerns. What I would also like to do is say thank you for all the response we've received, both in the 50-plus submissions as part of the scrutiny process and also subsequently. There are obviously many that do not agree with one of the proposals. There are also many that do support it. And I want to thank those who've written or spoken to me personally. In terms of our findings, as members will see, there have been a number of inaccuracies, typos and spelling mistakes that we've also picked up. This is post the amendments we've just approved. We found a number of issues of contention in the law which we felt required more attention, more clarification, great uncertainty, particularly on issues of religion which are significantly affected by the draft law. And therefore we, as part of our review, have agreed to bring forward a number of amendments which attempt to address these issues, and I'll be taking members through these. Before I do so, I really want to issue a disclaimer, and this kind of discussion we've just had indicates the issue. This has been a very complex law that makes fundamental changes to our marriage legislation. The difficult questions it raises require very careful and considered answers. We do not feel that the public and key stakeholders, possibly even my panel, have had adequate time to provide all the answers that everybody's looking for on this. And as the Chief Minister has acknowledged, in fact the Deputy Chief Minister has acknowledged, the law has certainly been challenging and the word rushed has been used. So whilst we have sought to correct any errors or deficiencies, we do not guarantee the draft law does not contain any more of those. So our amendments attempt to address the ones that we have found, and I hope members will consider them properly and hopefully support them. And what I will try to do, sir, is try and thin down what I've been given and just work through the actual running order, because hopefully that's a little bit clearer. So, if we're looking at page 8, the First Amendment is very, very minor. Essentially, Part A just clarifies the definition for marriage celebrant, because it refers to any person mentioned in certain paragraphs, whereas actually the law actually refers to people described. They're not described in the references it makes, and so from a law drafting perspective, they should be mentioned, not described. A truly exciting thing in 1B is we've inserted a comma. So it's not marriage birth, it's marriage birth. Now, what's that one? Sorry, I'm just trying to make sure I don't lose track between the two, sir. So at the bottom of page 8, going over to page 9, Amendment 2. Now, this is one that certainly Deputy Dibley has, and her organisation, well, the organisation she connected with, did raise with us. And so, essentially, the wording is we are inserting on page 9 at the very top a new paragraph which says BA. And what it is that the role of civil celebrant referenced in this article is new, and we felt it important the correct level of governance around that role is enshrined within the law. And we believe that the matters to be taken into account by the Minister, because the Minister's prescribing a scheme here, should include whether a civil celebrant who holds themselves out to represent a particular organisation has the appropriate qualification from that organisation. And trying to put that loosely, if somebody comes along and says, I can do you a humanist wedding, you want to know that they are affiliated to and qualified with the relevant humanist organisation, not humanists of Rhone, which had just been set up a week ago. And so that's what we're trying to achieve there. In the second part to that, which is under 6, it starts paragraph 6, an authorised civil celebrant must carry out solemnisation of marriages, and then A, in compliance with the requirements of the law and with any guidance. And so basically that's a requirement that people must comply with the guidance issued by the Superintendent Registrar. And that was just really a clarification. You'll see that we bring in guidance in one of our amendments later, but generally this was the only requirement for them to comply with guidance. Now, let's just try it. Right. And that's that one. And that's that one. So, the next one starts getting possibly more controversial, one might say. Now, so on page 9, now the point I would make, sir, this is all one part of amendment. When we get to there will be separate votes. The idea is that the bit I've just described is one vote, and then the bit I'm about to describe is separate votes, and I'll explain, or try to explain procedure shortly. Now, in Article 7, so 7, as it's written on page 9, in itself just represents a redrafting. It does not particularly change, or it does not change the meaning of the existing Article 7 that is there. So what we're trying to do is just improve it in terms of modifying the language. But we are advised that the wording represents an improvement on that originally presented to the Assembly. I will just say, unfortunately, because of the way it's been drafted, this particular article can't be separated out from the overall discussion around what one might call a tolerance clause. Now, and that starts on page 10, and that's 7A. So this article is introducing what's referred to as a tolerance clause. Some people have called it a no compulsion clause. Now, there are several elements to this. One is provision so that a person who objects on the grounds of religious conviction cannot be compelled to provide goods or services to a marriage ceremony or in any social event or functions associated with and subsequent to a marriage ceremony. It does contain provisions to limit that clause so that it does not apply to the public sector or employees and certain other groups, including officials. And also, sir, it makes provision so that religious groups who own certain buildings cannot be compelled to provide those buildings for the purposes of same-sex marriage. And I'll focus on the buildings in a minute. But what if this article is adopted in any shape or form in terms of the 7A, either with the tolerance clause or without it, an amendment to the discrimination law is required, and that is a later amendment. But we've been advised that it needs to be taken separately in terms of debating and voting on consequential amendments. Now, procedurally, to allow a separate vote on the tolerance clause aspect, this is why we have a separate amendment, which when I finish speaking on these, we will then go to dealing with, and that will be the focus on the tolerance clause aspect. But what I would like to do is just explain the provision for buildings. And on 7A, which is on page 10 and 11 of the running order, paragraph 1 talks about, I'm just wondering if this is going to be too complicated or, right.
At the moment, if it may help you, Deputy, you're proposing your second amendment.
Yes, sir.
And we're going to come on and ask you to propose the amendment later.
No, sir. Yes, sir, but this aspect is, the amendment to the amendment withdraws part of what I'm talking about, essentially. So I've advised that I have to talk about the buildings aspect during this part of the debate. So, the way the tolerance clause works is that paragraph 1 says that no one in paragraph 2 can be compelled to participate in a same-sex marriage. That's broadly speaking consistent with what's been happening in 7 anyway. Paragraph 2 gives the list of people, and paragraph 3 defines what's meant by participation. Now, with regard to buildings, paragraph 2b, which will read, because of the amendment we've just proposed, it will be the owner or trustee of a location, not an approved location, in a case where either the owner or trustee is a religious organisation or the location's primary use relates to the activities of the owner or principal occupier, and members can see it there, or to the activities or objects of the trust concerned as a religious organisation. What this paragraph does, sir, is capture, as we're advised and certainly are intending, this captures things such as buildings like church halls, which are owned by the church, which fall outside of the curtilage of church grounds. Now, an example might be St Brillade's Church Hall, which is situated across the road from St Brillade's Church. It might include buildings that are used as a church hall, which are situated outside the curtilage and owned in trust by a religious organisation, not by the religious organisation itself. An example of that would include St Paul's Centre. Also, it would include buildings that are used as a church hall, but which are owned by another body, such as a parish. An example of that, we believe, includes Caldwell Hall in St Clement's, which is situated next to St Clement's Parish Church, but is owned by the parish. And so we received an evidence from a number of the religious groups who made submissions to us, which suggested that such buildings might not be covered by the existing quadruple lock. It's already set out in the draft law. I will just say, and one will see that as an amendment lodged by the Deputy Chief Minister, which broadly speaking achieves the same as what we're trying to achieve. We'll touch on that. But basically, that this aspect from, I would think it would be safe to say, from all sides of the argument is generally supported. In other words, this is about, can church organisations be compelled to use their church halls for uses that they would not fit into their beliefs? And just to give an example, they are already sensitive around things like yoga classes, or things which have got a spiritual element to them, because that doesn't fit in with how they with their faiths. It does might include, they might be sensitive about allowing a rock band in there, depending what the lyrics are. So there is a sensitivity about how they use the church halls already. And what we've also tried to make clear, sir, is we are not intending to capture hotels or other locations where a same-sex couple may want to hold their ceremony or reception. It's about, the aim is basically, I'll use church halls as the analogy, because at the moment that's not covered under the existing legislation. So, as with the rest of the tolerance clause, the idea is not to compel people to participate if they feel they cannot on the basis of their religious convictions. If a religious organisation did want to host a same-sex marriage or something, or wedding reception in their church hall, then they are free to do so. So it's about not compelling, it's not about not preventing. And the aim is to provide a reasonable level of protection, again, not to compel. Now, we believe it's a reasonable amendment, and I hope members will support this if they can, even if they do not support the rest of the tolerance clause. Now, I shall touch briefly on the tolerance clause. Amendment, as I've said, how it works in the debate is that once the finished debate are talking about these amendments, we then move straight on to a debate on the tolerance clause, by the end of which I suspect my voice will have run out. That debate will be whether to remove it or not. So essentially, it's a procedural device. It's all encompassed in Article 7A. We are then debating whether to take the tolerance clause out of it. It is basically the way to achieve a separate vote. Now, it's very clear it's an important subject for many people on both sides of the argument, and also based on the submissions we've received. It's not uncontroversial, and it wasn't a unanimous decision. So panel members will no doubt express their own views on the matter during the debate. However, it is an important matter that the states should debate. And it is therefore important, that's why we've lodged an amendment to enable this. But basically, when we get to our next amendment, if members support the wider tolerance clause, they should vote against the amendment. If they do not, if they do not support the wider tolerance clause, then they should vote for that amendment because it will take it out. Hopefully that will become clear as we're going through. Now, if we then go to page 11, so what this is, firstly, is a minor change on grammar, which hopefully is not too controversial. We then actually want to bring in some clarification about religious content, and this is, again, Chief Minister supports this. There are two paragraphs in the actual law which relate to one another. One says, and this is 17.8, I think it is in the main law, a civil marriage celebrant must not permit, basically, any religious material to be included in a wedding. That's the starting point. But then in paragraph 9, it says, if satisfied, that civil marriage celebrant, if it doesn't contravene what I've just said, must permit any religious content to be included. And so what we rather felt is that it looked contradictory. How are people going to interpret that? So what we're basically saying is that the superintendent registrar, I can see people frowning at this already, and yes, one can therefore understand the kind of discussions we've been having. What we're basically saying is that there needs to be some clarification on there. The superintendent registrar should consult as to what is religious content and then issue some guidance. That's it. It shouldn't be something that we are trying to decide or somebody on the day is trying to decide. There needs to be clarification as to what is or isn't religious content for the purposes of those articles.
So with this speaking, wait, sorry, who does the superintendent registrar consult in order to find that out?
Basically, so he or she consults the relevant religious organisations, sir. But that he can consult anybody else as well, I guess.
Have you finished? Right, then the time for questions will be later on.
Right, sir. Now, sir, we're now onto page 13. I'm sorry, I'm just doubling because this repeats twice. Sorry, sir, we have gone to, I've done page 11. Page 12 is basically a repetition of what we've just covered, but that's to do with conversion ceremonies, and there is also a correction on some typos in there. Page 13, which is now Amendment 5, Right, sir. The issue on this is that Article 23, so Deputy Mesick may have some comments on that area, but this is part of the quadruple lock. Again, this is an amendment to try and approve it. It doesn't remove Article 23. This basically deals with locations where marriages can be solemnised in Jersey and the process for approving those locations. It contains provisions to protect some but not all places of religious worship, because it talks about usual places of public religious worship. And when we were examining it through it, this would not, for example, capture chapels and other consecrated buildings that are not a usual place of public religious worship. Now, that could include private chapels. We originally thought it could include, for example, the chapel at Hoogby. Now, since we actually lodged the amendment going through it, we understand that actually Hoogby is covered, because Hoogby actually forms part of the parish of Greville, in terms of it's part of the parish church, it's on the website, and so it's an Anglican chapel, and therefore basically through the interactions of canon law and those areas, they could not be compelled, it cannot be used for same-sex marriages. What we're looking at is generally about compulsion or not. And as I said, what we're trying to do is to achieve protection, if that's the right word, where appropriate, for areas that are not quite well defined in the law. So the present use of public religious worship is quite restrictive. Now, we will again get to an amendment, because there is an amendment on this being lodged by the Deputy Chief Minister, which broadly speaking we are accepting, and I think we'll have the discussion at that point as what's being achieved there. Right, and I think after that we get to a nice easy one, which is at the bottom of page 13, which is Article 35, which basically contains some cross-referencing errors. So if you don't actually want to approve that, it would mean the law would probably not make that much sense in relation to it, because essentially Article 35 isn't amended, but the articles it refers to have been amended in the original law. I think I shall just say there, sir, that this, as we've said, is a very complex law that makes fundamental changes to our marriage legislation. And I hope the panel's amendments have gone some way to kind of illustrating the complexity of the issues we've had to deal with. I have gone slightly lighter, because hopefully those who didn't come to the presentation on, I think it was Monday, felt they already knew the matter. We did cover it, some aspects on Monday as to some of the details that came through. Whilst we have sought to correct any errors or deficiencies that we have been made aware of, we cannot guarantee the draft law does not contain any more. And I do hope that you will agree with me that our amendments attempt to address the ones that we found, and that members will support them. Now, sir, if I'm correct, at that point, I sit down and I propose, that's me proposing the amendment. Somebody needs to second it, and then I presume we then commence with our amendment on the tolerance clause. Thank you, sir.
Is the amendment seconded?
Yes, sir.
Very well. We now come on your running order. If you go to page 14, halfway down the page, the second amendment's been proposed, and the chairman of the Corporate Services Panel is now going to propose his amendment to the second amendment. Sorry? Sorry? Yes, I think so. He's going to propose his amendment to the second amendment, and I'll ask the greffier to read the amendment.
Page 4, Amendment 2.2, in the substituted Article 7A, A, in paragraph 2(1), at the end of subparagraph C, after the semicolon, add the word and. 2, at the end of subparagraph D, for the semicolon, substitute a comma and delete the word and. 3, delete subparagraph E, and B, delete paragraph 4.
Thank you, sir. For the avoidance of doubt, actually, what was circulated just earlier today, which is from myself, will show members the article basically we are debating and what the consequences would be of this amendment. Basically, this amendment puts in the paragraph, or puts in the striking out, if that makes sense, of the paragraphs in this article. So essentially it deletes the articles that are marked with a strike through. Okay. Now, sir, this is going to be the most controversial aspect of this whole debate, and it is right, therefore, I do talk to it to a degree of length, because it's the only time I will have other than summing up. I want to make it very clear at the very start that even though the panel is not unanimous on this amendment, we are unanimous in our support for what I'll refer to as Article 2, which is actually what we would call Article 2, which is about the introduction of same-sex marriages. And we've made it very clear from the start of our review that this was the case. And the reason I start this way is that there is a real risk that the debate degenerates into a slanging match of people accusing others of racism and homophobia. But I remind members that not only did I support the principles of this law, and I support what I've referred to as Article 2, but previously when I've been present in the Assembly, I've also supported civil partnerships. However, the principal point of this debate is about freedom of speech, freedom of belief, and freedom of expression. Freedom of speech can be uncomfortable, but it is critical to a democratic society. This is an important subject, and it is therefore right that this Assembly should debate it. I suspect certain people's minds are already made up, ears are closed, as it were, but I hope we have made people think. I do, however, urge members, let's try to keep the debate respectful rather than, as did happen in one of the earlier debates, building up images of neo-Nazis and things. To summarise, this is sometimes referred to as a no compulsion clause or a tolerance clause. It is about enabling someone not to be compelled to participate in same-sex marriages should they not wish to, as a result of their deeply held religious convictions. In many faiths, marriage is defined as being between a man and a woman, and I will talk to that later. But for the avoidance of doubt, we are advised it does not capture hotels, and it specifically does not apply to employees or officials. And the Attorney General has given his opinion that it is human rights compliant. So, 11 years ago, a minister brought a law to this Assembly, and within it there was an article which said, amongst other things, that a person committed an offence if they displayed any sign that was insulting within the hearing or sight of someone likely to be caused distress by the sign. Now think about that for a moment, because I was one of the first as an assistant minister to question this because I was concerned about freedom of expression. Think of the miners' strike in the 80s, death to Thatcher. I didn't agree with the wording, but I absolutely defend the right of someone to say it. And at that point, so I was rapidly followed by the then Minister for Education, who agreed with me. They didn't have collective responsibility in those days, and the debate rather rapidly fell apart, and that proposition was withdrawn. Now, just as an example, sir, somebody said, yes, you've made it. I don't know if anybody saw the JEP of yesterday, which was the cartoon, which has a devil whispering in my ear saying, how can scrutiny propose a conscience clause, Deputy Le Fondre? Now, actually, I muttered a couple of things, in the end I laughed, but it is actually potentially clearly offensive to me. And I would suggest also to actually anyone who has emailed in or written into us in support of a tolerance clause, as basically it says that I and they are evil. However, I support their freedom, their rights to freedom of expression, even if I am offended by it. And the reason I refer to that, sir, is that freedom of speech and freedom of expression can be uncomfortable. It can be upsetting, it can be shocking, but it is important. And I want to talk, sir, today as well about faith, belief, and conviction. Now, today, most of this assembly prayed to God. We prayed to God for guidance and for prudence, for his blessing, and we prayed to him in the name of Jesus Christ, and then we said the Lord's Prayer in French. Now, unless anyone's being hypocritical in the assembly, I would assume that those who regularly stay in the assembly for prayers probably have some level of faith. Many of us who are not senators also have another connection. Many of the parishes we represent have a religious connection. The Church of England is embedded within the parish, as it is in this assembly in the welcome guise of the Dean. The reason I mention all of that, sir, is that it seems to me it is therefore recognised that religion has a very special place in this island society. Yes, it might have declined, but it is still strong. And I always have to introduce some numbers into a speech. So if there are around 70,000 adults on the island, just under 40,000 have declared they have a faith in one of the annual social services, basically, if you use that. And around half of them are Catholic, if my numbers are correct. That latter figure is statistically much higher than the UK. Now, as an indication, 2011 census showed that there are approximately 440 people living as couples in same-sex relationships, and I do appreciate it's likely to be higher now, and also does not include individuals who are not in a relationship. So even last year, and probably this year, in another country, maybe 3,000 or 4,000 miles away, people are dying because of their faith. A couple of years ago, I met a man on holiday. He was with his family and was returning to his home country a couple of days later. He was a Coptic Christian from Egypt, and to be honest, I've absolutely no idea how that came into the conversation. But at that point, Christian churches in Egypt were being targeted and bombed. And I have no idea if that man or his family are still alive today. But to relegate faith to an anachronism is just to completely fail to recognize its strength and what it still means to many thousands of the population on this island. And a fundamental part of the teachings of many faiths is that marriage is defined as being between a man and a woman. And by way of example, only by way of example, I shall refer to the Church of England and canon law. Now, contrary to some remarks made recently, canon law isn't just a body of internal rules and regulations governing the organisation. It does apply to members of the Church, but it also, as I understand it, is an elaborate code of ethics shaping family life, and in this regard, marriage. And as we said, both in our report and at the presentation on Monday, we actually showed where it was and where it defines marriage as the union between a man and a woman. But to quote actually from P179 2010, when this assembly approved an update to canon law, which is what I've just referred to, members may wonder why they're being asked to consider this matter. The answer is Jersey's relationship to the Crown. The Church is established under the Crown, and nothing in the canons can be amended without the mutual consent, probably at that point, sir, of the Bishop of Winchester, the Dean of Jersey, the clergy meeting in the Ecclesiastical Court, and the government of the island. In 1623, that meant the governor, bailiff, and jurats. It now means the states of Jersey. Whatever the personal beliefs of individual members, it is the responsibility of the states as a whole to ensure that the freedoms of the Church in Jersey, enshrined in the 1623 canons, are preserved and enhanced in the amended canons, which was what was being brought in 2010. It is the view of the Dean, the Ecclesiastical Court, the Island Synod, and the Bishop of Winchester that these canons provide a solid legal framework within which the Church can fulfil its ministry, both before God and as a channel of his love to the island. That's directly from the report that this states approved with the proposition. The reason I have taken the time on that, sir, is to illustrate how important the definition of marriage may be, or can be, or is, to people with a faith. And so I also remind members of our oath of office for senators and deputies, obviously connotabs are slightly different, which says that you will uphold and maintain the laws, privileges, liberties, and franchises of Jersey, opposing whomsoever may wish to infringe the same. The point here is that religious faith is a powerful thing. In Jersey, it is generally a personal and private matter, but that does not weaken its standing. That does not weaken what it means to many people on this island. And the question for this assembly is whether it is right in the name of equality to force someone to adhere to a doctrine which we are introducing by state law, which is fundamentally against their religious beliefs, or as an alternative to put in a measure which enables them to be compelled to participate if it goes against their beliefs. If they wish to participate, they can. So this is not about not serving someone because they are gay. Anyone who does try to use that as an argument just does not want to engage on this, does not want to understand. I assume everyone in this debate condemns homophobic behaviour. This is about maintaining the right to say no, to not be felt forced to endorse a type of marriage, to mark a marriage which is fundamentally against their religious beliefs. This has already been given to the clergy. What one is arguing here is why should it not also be given in certain circumstances to the followers, to the ones that receive the teachings from the clergy. I use the clergy in the wider sense. I want to quote from an article, the article that was presented to us in one of the submissions which we received, and was actually recently circulated to all of us. And it was by a man called Peter Tatchell, who is a gay rights activist and campaigner. It's an article that was written in The Guardian, sir, and was one of the organisers of the first gay pride march in London in the early 70s. And at the end of the article, what he says is, I profoundly disagree with Ashes Bakery's opposition to same-sex love. Ashes Bakery is one of the key cases that gets cited a lot about freedom of expression, and it's in Northern Ireland. But believe the discrimination verdict infringes vital freedoms. In my view, it is an infringement of freedom to require businesses to aid the promotion of ideas to which they conscientiously object. Discrimination against people should be unlawful, but not against ideas. So this is the problem in a nutshell. How, in a democratic liberal society, do we ensure that the freedom of speech and expression of one group does not happen at the expense of another? Let's be clear, this is not about seeking to exempt big companies, local supermarkets, or larger wedding providers. And I note the open letter from wedding providers, certainly. In reality, any significant entity would face a public backlash if they refuse to provide for a same-sex marriage. It is about avoiding someone being prosecuted for following the religious teachings of their church and their strongly held faith, beliefs which in certain circumstances are backed up by long-standing law of the land as approved by this assembly. Otherwise, are we in danger of incriminating the innocent? Let me suggest some scenarios. Imagine a church choir, and say 4 ladies set up a smaller quartet to extend their singing. And over time they get asked, perhaps by friends, to sing at a couple of wedding receptions or even a wedding ceremony. They are religious. Then someone asks them to sing at a same-sex wedding or reception. The situation under the present proposed law will be that they will be guilty of discrimination if they say no, because they will be providing a commercial service. Doesn't matter how nice they are, doesn't matter if they suggest someone else, as we've understood that they can be taken to a tribunal or a court, fined, possibly required to undergo some form of equality training or education, if you prefer to call it that. And I say that based on experiences in the USA and the UK. They have been asked to decide between their deeply held beliefs and what the state is telling them to think. Now, interestingly enough, and we all had I had this example in mind, and then this email came through which we've received, and I think we all received it again yesterday. But it was sent to us by a lady. If a same-sex couple with an adopted child came to my services, then I would gladly receive them and treat them with the love, compassion, and dedication that I show all the families that I work with. However, I'm also a singer. Should this same couple ask me to sing at their upcoming wedding, would I be allowed to maturely, kindly, and politely say no, and then refer them on to someone else who would be better suited to their needs in this instance? Or would they, or could they, that's my assertion, sue me or take me to court for discrimination? I've obviously shown in my conduct that I'm not a bigot. However, there are certain beliefs that I hold dear that affect the choices I currently have. I currently have the freedom to make in life. Can this position be respected, or am I to be forced to sing with a perceived gun to my head in the name of equality? It may be difficult for some to understand my position, but God's ways have saved my marriage, healed my body, given me a love for life, and so much more. I have had very real life-changing experience through the Holy Spirit and have committed my life to follow His ways as a consequence. Can we have scope in our society to allow people to act maturely and say that they are not the best person or the best place for the job in hand because of their conscience without it being taken as hateful? Please may it be so. And I must admit, when I read that, I found that's what one's trying to deal with here. Any church organist, as we've understood it, sir, who is contracted, say, to more than one church, would find themselves forced to participate potentially in a same-sex marriage, even if it was against their beliefs, if one of those churches decided to allow such marriages. That's a future potential. For the avoidance of doubt, it is very likely that the 3 examples I've just given would count as a provision of a commercial service. Then, sir, I don't think any debate on this matter would be complete without mention of cakes, unfortunately, in particular wedding cakes. And again, similar scenario. Someone who makes specialist decorative cakes might specialise in wedding cakes. If, as a matter of their faith, they do not support same-sex couples, at present, if they politely decline the business, they'll be taken to a tribunal and or fined, etc., etc. And this is the type of example that is occurring in other jurisdictions. That was what the Peter Tatchell article referred to. This is where a Catholic baker in Northern Ireland was asked to produce a wedding cake promoting same-sex marriage. They refused and were found guilty of discrimination. Now that case continues to work its way up through the court system. Now, and this was part of a submission, and this did stun me slightly. In the USA, there is a baker who's refused to bake a cake celebrating Satan. It would seem that in the USA, Satanists are a religious group, recognized religious group, and therefore can't be discriminated. That they were exerting their rights, basically. And for the avoidance of doubt, the cake will be a commercial good. And that's the type of scenarios that we're trying to deal with. And as a guide, in the UK, there are around 200 inquiries each year now around the conflicts between discrimination legislation and matters of religious belief. So this is not aimed at big business. I don't like the term, but it's aimed at the little guy. We risk saying that they do not matter, that their fundamental beliefs do not matter, that we do not care about them. But even worse, that their faith does not matter, and they actually could be sent, if you use some of the examples from the US, I'm not sure about the UK, for re-education, retraining, if they express their thoughts. Now, I do want to refer to the open letter from Liberate, which we received, I think it was yesterday. And I utterly agree with them that they have treated this matter with respect. However, I do disagree with something else that they included in their letter. Being prevented from acting on deeply held beliefs by the law of the land is not discrimination. For example, a person might hold a deep belief about the amount of tax the richest 10% of the population should pay. This is not an extreme belief. Many people think that the rich do not pay enough tax and believe that passionately and sincerely, and then they carry on. Now, I'm sorry, because I said Liberate have been very respectful all the way through, but I feel that this completely belittles and fails to understand what faith is to many people on this island. That's been the principle of what I've been trying to demonstrate in the early speech. Sometimes gets likened to believing in Santa Claus. Again, same point. For people who have a strong faith, it will guide how they live their lives. That is not the same as someone saying that people should pay more tax. And that is part of this problem. It is not about whether anyone in this assembly does or does not have a faith. It's about whether we are capable of recognizing that many people on this island do. So, equally, reference has been made that that freedom and equality are paramount, and moreover, for people of faith to practice their religious beliefs, and this is the crucial bit, within the bounds of the law should be upheld. Now that sounds all well and good. But what happens when that law changes and conflicts with those religious beliefs? Because that is effectively what we're doing here. Free speech must apply to people's deeply held religious beliefs and the protection of their rights to express those views in peace, and I'm one of those speaking out on their behalf. So what happens if nothing is done? My real concern is that not having an opt-out clause, and no compulsion clause, may well garner resentment or other unintended consequences. Now, in case members missed the point, at a public hearing just before Christmas in front of us on this matter, the Roman Catholic Dean stated that the Catholic Church in Jersey would be seeking to remove itself from providing the legal element in any marriage service. That means, as a direct result of this legislation, any Catholic couple wanting to have a church wedding will have to have a separate civil marriage first. Now, some people will say that doesn't matter. It's what happens elsewhere. But it did used to happen here, in terms of you could have one service. Not in itself a big thing, but does that not demonstrate the strength of feeling on this? Anecdotally, we've had a couple of reports already of individuals withdrawing their service because of the perceived conflict between this law and their beliefs. And what I found fascinating on this is you can't actually say who believes in what without actually asking them. There are different views within the church, both for and against. There was the report from the member of the clergy in Guernsey, who is part of the LGBT community, and also on General Synod, and obviously against these proposals. Equally, we received an email from someone also part of that same community, the LGBT community, in support of our proposals. And that actually was backed up by a conversation I had with someone very recently. We've been receiving lots of messages, both in support and against. Now, if it is about beating up the church, well, that's a different story. From the most recent article in the JP last Thursday, I didn't realise that the Church of England in Jersey was such a checkered organisation. But I think I'll let the Dean deal with that, and other than to say that it is that type of opinion or article from a public commentator that stops proper debate on this. And if anything, the purpose of today is to try and at least have that proper debate. Liberate and the church organisations have been very responsible in the build-up to this, no question. Others haven't always been. To address one point, one letter we received recently stated the following: if the law is to allow same-sex marriage, it should do so completely and without giving any person or organisation the ability to opt out of that law. If groups or individuals are allowed to discriminate against same-sex couples, the door will be open for the argument to be made to allow other types of discrimination to be acceptable as well. And as a theme, this has cropped up a number of times, i.e. there should be no discrimination. Well, the problem here is that we do discriminate. Actually, sir, that's the extract from the discrimination law, and all of those, roughly 20 to 25 pages, are the carve-outs in the discrimination law. And I'll give some examples. We actually discriminate against transgender people. Now, I appreciate there may be biological complexities here in terms of impact of medication after a period of time. But from what I've looked at, I'm not a lawyer, that's not what the law says. The law says that, for example, a man who becomes legally a woman, has all the treatments, has had all the documentation amended, including their birth certificates, they are legally a woman for all intents and purposes, but they can be discriminated against if it is necessary for fair competition, in sports, for example. So that woman cannot take part in, say, competitive track events. Now, I can understand in the law there's a good reason for it, but there is discrimination even though she is legally a woman. The law specifically allows a minister to discriminate on racial grounds. Again, when you look at the clause, there are justifiable reasons for this, but that is what the law says. We've recently agreed that the people from outside the EEA will have to take an English language test. Tell me why that isn't discrimination. Perhaps the most peculiar matter, and I know a number of us will be members of these, but in the context of being against discrimination, we allow in the law certain clubs to discriminate on grounds of sex. There are women-only clubs, and there are clubs which will not allow women in to what is basically a restaurant because they are women. And we are apparently all fine with that because that's been defined in the law. That is discrimination that is allowed. So we are happy to allow a club that is basically a restaurant to discriminate on the grounds of sex, which is a protected characteristic, because it's in their constitution. But apparently we are not happy to avoid people forcing people to act against their deeply held religious beliefs, even when the basis, in one instance, for that belief has been defined in a law passed by this Assembly. Now, I'm going to direct my next comment, because I know Senator Green's dying to come in with his normal enthusiasm, as to tell me why we're so wrong on that matter. So I hope he's listening at this particular bit. We must not discriminate has been his stance in the discussions we've had with him. And I've already outlined where we do discriminate. But Senator Green has proposed this whole set of amendments already, which include what will be Articles 7, 15, 23, and the changes to the discrimination law in the schedule. These all, in effect, discriminate. They discriminate against same-sex marriages. They give carve-outs to people who charge for their services who have deep religious conviction, namely the clergy in the wider sense. Therefore, what Senator Green is actually saying is that discrimination is okay if he agrees with it. That's probably slightly unfair, and I'm sure he'll defend it, but think about that, because the no discrimination argument isn't consistent. We do discriminate, we already discriminate in law, and we are discriminating in this law as well. Now, just for the avoidance of doubt, I absolutely do support the carve-out for clergy, but make no mistake, it's a set of conscience clauses, and it is discriminatory in the wider sense. Now, I have touched on the complexities we as a panel have faced. Now, there may be members who get the general principle of what we're trying to do, but might think the amendment is too wide. If this is the case, can I really do urge members to say so, and whether something narrower would be acceptable for the sake of argument? This has been a very time-pressurised review. The Chief Minister only lodged his last amendment yesterday, so it would, in the very least, inform the debate overall. Now, we have had discussions, for example, about whether it should apply just to individuals. The amendment refers to person, but a person includes a legal entity. But actually, even small operators could use a company. But in practice, anybody that is a large business will not wish to opt out, as there will undoubtedly be consequences. This is about giving them choice. Now, in my speech, I've generally talked about religious beliefs. As a safeguard, the proposed amendment talks about conviction. That's a higher test, we are advised. In addition, and in accordance with other existing law, we are advised that the burden of proof for any conscientious objection shall rest on the person claiming to rely on it, because we all agree this must not be a means to protect homophobia. So this isn't a get-out-of-jail-free card. This is about not forcing someone to go against their deeply held convictions, religious convictions. But if that was ever tested, they would have to demonstrate to the satisfaction of the court that they meet the test. And members will be delighted now and starting to wind up. We're not quite there yet, but anyway. So, in this assembly, we have the ultimate privilege as regards freedom of speech. But as soon as we leave this chamber, we lose it. Members of the public do not have our privilege. They are dependent on laws to protect their freedoms. And what I'd like to do is, in starting to wrap up, is quote from an article in the Independent newspaper. Freedom of speech without the freedom to offend is not only a meaningless idea, it's a dangerous one. And it's quietly gaining ground. If I can frighten you into silence by claiming your ideas upset me, then your right to free speech becomes purely theoretical, like the right to jump over the moon. This language of offence can suddenly be heard everywhere, even among so-called liberals. Under the new unspoken rules of liberal discourse, you can win a debate, not by producing a killer argument or fact, but by claiming you're offended, ideally by somehow invoking minority or victim status. This is the article. The day we lose our right to openly mock or offend, we can kiss our right to free speech goodbye. And without free speech, all our other freedoms are under threat because we won't know how to protest when they come under attack. End of quote. So ideally, all parties would respect each other, and there would be no conflict on this matter. Those involved on all sides of the argument have been oppressed at different times in history and continue to be oppressed in different jurisdictions even today. But unfortunately, there are individuals on both sides who will push matters much further. And even during the period of our review, various parties have suffered some form of abuse during very recent times. 2 individuals who appeared before us, having received verbal abuse on this matter in the last few weeks, 2 individuals, including 1 panel member, being trolled online as a result of what they have been reported as saying. And comments are sometimes made, equating those expressing support for Christian views as being old-fashioned, quaint, Nazis, or racist. We have sought to try to understand the various perspectives on these arguments, and it has not been easy. But in the event, the panel felt that a tolerance clause should be debated. Freedom of speech is a basic tenet of our society. It is a balance of competing rights and can be extremely uncomfortable at times. But overall, that is what strengthens tolerance and understanding over time. If we force people to comply with ideas they do not agree with, this can ultimately lead to a greater hidden intolerance and unintended consequences. It does not matter which is the bigger minority in this area. This law is about allowing one minority greater equality, which is a good thing. And this amendment is about allowing a different minority to disagree in certain circumstances, to not be compelled to do something. Now, so to cite the Deputy President of the Supreme Court, as detailed in the report to P91, she has publicly stated that the law should protect people's rights to refuse to do things against their belief, even if those beliefs clashed with equality laws. In a healthy democracy, both genuine human rights and the right to express dissident minority opinions should be treasured. This is why we felt it was important to bring this matter to this Assembly. It is not something that could be ignored, and it is a sensitive subject, but we'd be shirking in our duty to islanders if we did not, at the very least, debate it. This matter is going to both the UK and USA Supreme Courts, and no doubt will continue to do so. This debate will no doubt be passionate. Please let's try to keep it measured and respectful. And I finish, sir, with two quotes. I remind members of the quote from Peter Tatchell. In my view, it is an infringement of freedom to require businesses to aid the promotion of ideas to which they conscientiously object. Discrimination against people should be unlawful, but not against ideas. And as I said, he was one of the first, or the organisers in the early 70s of the first Gay Pride March in London. And you think about those times. Finally, a famous quote. I disapprove of what you say, but I'll defend to the death your right to say it. And at that point, sir, I make the amendment.
Amendment seconded. Does any member wish to speak?
Sir,
Deputy Martin.
I'm not sure if I want to speak. Yes, I want to give notice to the Solicitor General. I'd like some advice after restudying the words of the Attorney General, the written words, sorry, through 22, 23 and 24. Am I completely reading this right before we get into the debate, that if this compulsion, this tolerance clause was passed, it only has effect to the provider who is the owner, but the provider who even is the owner, who may have no tolerance, can compel or can instruct their employee to carry out the service. Or it may be an employee who doesn't agree with the tolerance clause, but the employee holds the the religious rights or thoughts that the deputy has been free to express and apply to those who, have strong religious beliefs. But they are only the employee. And if I'm reading this right, I'm asking for a legal advice. Is there no other law, like our employment law, JACS, that would protect an employee who says no? Because I'd like that clarified. If it's short notice, obviously the Solicitor General can do it somewhere along the debate. But I think we need to know that there'll be many people who will not be protected by this, if I'm reading it right, sir. So it is just notice. At the moment, I don't intend to speak unless you make me or compel me to, sir.
I'll discriminate in your favour on that. But, who says no to what? What's the question to the Solicitor General?
Well, it's the Deputy in his speech said it's human right compliance, and the Attorney General has given us comments. And when you read 22, 23 or 24 of the Attorney General's comments, I actually I want to know if there is something that protects an employee under one of our other laws. It seems to be missing here, but I don't know.
Protects the employee from what?
To being compelled to carry out something that's against their deep religious beliefs.
I see.
Thank you.
Well, when you're ready, Solicitor General. But no? No, right.
So I don't know if I can help on that or not. But
You'll have a chance to answer later on. Does any member wish to speak? Senator Green.
Thanks, sir. I'd like to start off positively, sir, by again thanking the panel for its work. And I will be voting, and I urge members to vote to accept most of the panel's amendments as set out in their second amendment, except for paragraph brackets 2 of their amendment, which relates to their proposed Articles 7 and 7A. And also I urge members to vote against their fifth amendment, which relates to proposed changes to Article 23. Before I explain why I will vote against them, I think it might be helpful if I positively outline why my reasons for accepting the other proposed amendments.
So you are aware, aren't you, that we're on the amendment to the amendment? We're not on the amendment itself at the moment.
Yes. So the amendment to the amendment. Okay, so I'll just come back in a minute, if I may.
Well, that's not entirely in accordance with standing orders, but that is rather against them. You'd be speaking
Okay, sir.
twice.
Just give me 2 minutes to find my place then, please, sir.
So could we raise the DEFO on Senator Razor?
Propose the DEFO be raised on Senator Razor. The DEFO is raised.
So I apologise for not being in the Assembly for personal matters.
Right, sir. Okay, now. Sorry? No, I think I'm okay. So I obviously got my running order slightly wrong there, so I hope I'm in the right place now. Because I think, please correct me if I'm wrong, that we are talking about the amendment to the amendment which covers 7 and 7A?
Yes.
Okay. Thank you.
7A, yeah.
Okay, sir. So the panel referred to 7A as a tolerance clause. So, but I don't see it as a tolerance clause. I'd like to call it actually, trying to be respectful, a no compulsion clause, as I think this more accurately reflects the title of the proposed Article 7A and its effect. So it's not clear to me how Article 7A as proposed could be considered to engender tolerance. For the avoidance of doubt, I do not support the panel's no compulsion clause, either in its broad form, as set out in Amendment 2, or its narrower form that they themselves propose as their amendment to the amendment. So, however, perhaps being accused of voting tactically, when asked to vote on the amended narrower clause, I will, and this might surprise people, and I urge members to do the same, I will vote in favour of the narrower clause, the amendment, not because I actually support it, but because I want to vote tactically to try and ensure that the broader no compulsion clause is defeated. Once the broader clause is, in its narrower form, if that's accepted by this Assembly, comes forward, I will vote against the clause in total, sir. I think that's all I've got to say about the at this stage, sir. I'd like to say a little bit more about picking up on some of Deputy Le Fondre's comments, why I can't support the compulsion clauses. I can't condone people being, as I see it, subject to discrimination. I'm trying to be as respectful as possible in this, sir. I know that there are people in our community that believe that marriage can only ever be a union between a man and a woman, and I respect their rights to hold that belief. In fact, indeed, I will defend their right to hold those beliefs and to speak of those beliefs freely. But that's not the same as providing in law a right for them to discriminate against others. Much has been said about the no compulsion clause, that we have been presented with a range of examples as to why it is needed. But let us be very clear, most of those examples are erroneous. Anyone can legitimately and publicly state that they do not believe that same-sex marriage is right or wrong. We do not need a compulsion clause for this. A person can wear a crucifix to work. We do not need a no compulsion clause for this. A religious organisation or official can refuse to marry a same-sex couple. We do not need to have a no compulsion clause for this. We have the quadruple lock, as Deputy Le Fondre referred to. A teacher, when talking about same-sex marriage, can explain that there are polarised views. We do not need a no compulsion clause for this. A student can post a blog denouncing same-sex marriage and keep their place at university. So again, there is no need for a no compulsion clause. So there are cases in the UK and elsewhere of people who have expressed their personal beliefs and have been wrongly dismissed from their jobs or marginalised in other ways. That is because the law there was poorly interpreted or misunderstood, not because the law is wrong in protecting all of us from discrimination. There is a simple litmus test. Apply the proposed no compulsion clause to a black person, to a disabled person, to a woman. Would you accept it then? No. I think members have told me very clearly no. And therefore, I call upon this Assembly to respectfully treat all people equally, to replace the panel's broad clause with the narrow clause, then vote against it, throw it out. Thank you, sir.
Deputy Bree.
Thank you very much, sir. The chairman of the Corporate Services Scrutiny Panel excuse me, mentioned in his speech that the panel were not unanimous. He mentions it in the panel's report as well. I'm vice chairman of that panel. I was the one dissenting voice against the tolerance clause. I spent a lot of yesterday trying to write a speech, and it ended up with a lot of crumpled paper in a waste paper bin. So I decided not to write a very clever speech calling on loads of evidence, but felt it more important to speak from the heart and from my conscience and explain the reasons why I fundamentally disagree with the so-called tolerance clause being extended to individuals and businesses. Before I do so, I would like just to say, I was brought up over here in a household that had very good Christian values. My father belongs to the Church of England. My mother was brought up a Methodist, so it was quite a mixture going on. But I do remember 3 values being taught to me: love, tolerance of others, and forgiveness. Now, if we look at the tolerance clause, what is actually at the heart of it? It is all about discrimination. And we are suggesting that because a person holds a certain set of religious convictions or beliefs, we should enshrine in law their right to discriminate against another section of society, purely on the base of their gender, sexual orientation. Now, that brings us to what is discrimination. It is a great shame that we as a society have to bring in discrimination laws, because we should all be living together, respecting other people, and not discriminating. But unfortunately, that is not human nature. There are groups of people, not only today but throughout history, who have sought to discriminate against another group. So what we, as a States Assembly and a government, decided to do was to create a protected characteristic of your gender, sexual orientation that protected that group of people from discrimination. That's what it was intended to do, to recognise the failings, if you want, of human nature, and to protect a group of people against open and very often violent discrimination. And I support that. We should all support that. Because what other discrimination laws are we looking at? Race. We're talking about bringing in disability discrimination. As I said, it is a great shame that we have to do that. But we recognise the problem and we are prepared to deal with it. So what this so-called tolerance clause, brought by the rest of the Corporate Services Scrutiny Panel, seeks to do is to allow one group of people to discriminate openly, and that's the point, openly, against another. We know that in this society we live in, there is a lot of discrimination, still. Perhaps we don't see it, perhaps it's hidden, but it exists. Now, at the moment, people cannot openly discriminate against a protected characteristic. I respect entirely people's own religious beliefs and convictions, and I will fight that they can have their own religious organisations, their own religious beliefs. But we are stepping across a line here which is about discrimination. And I think we also have to think very, very carefully about what society do we want to live in. I am a firm supporter of the same-sex marriage right from the word go. When I stood up on the hustings in the first place, it was a very, very topical subject. And my argument has always been, if two people, irrespective of their sex or gender, love each other, then they should be afforded exactly the same rights as any other member of the society we live in. The argument has been put that an individual or a business should be allowed to openly discriminate because they hold certain religious convictions. If you set yourself up as a business and you promote yourself as a business, providing services to marriage ceremonies, receptions, or parties to do with marriage, then to be allowed to discriminate against one group of people is wrong. You either say, I don't do any weddings or receptions, or you say, I do. Because that is what your business is. And I'm afraid that I so disagree with this view that it's okay because it's your religious conviction. It's okay because that's what I believe in. Well, being a student of history, all one has to look is back in history to go, I believe in this, therefore I can do this. We have to protect against any form of discrimination. And this law is not trying to compel any religious organisation, any clergyman, or any church to perform a same-sex marriage, which I have to say I'm not entirely happy with, but I respect their views. They're protected under this. The quadruple lock, as it's known, is giving them that protection. What the Corporate Services Scrutiny Panel, or should I say, Corporate Services Scrutiny Panel minus me, is trying to do is to say we need to be able to extend that to followers of that religious organisation. So outside of the church, outside of the protected environment, which this law is providing through the quadruple lock, the tolerance clause is designed to go, it's all about freedom of speech, freedom of belief, freedom of conviction. I should be able to say and do anything I want because of my religious conviction. Has anybody like me, sir, thought how absolutely absurd that statement is? Everybody is entitled by law to have their own religious beliefs, but it's when those spill out and cause discrimination against a minority in our society that we as a government have to step in and go, no, sorry, that's too far. And we get to a stage whereby that if we support Deputy Le Fondre as chairman and the rest of the Corporate Scrutiny Panel in their view that, but it's okay because that's my religious conviction, that's my religious belief, I am very, very concerned that we are nibbling away, chipping away at the floodgate that holds back and protects against discrimination. And I urge all members of this assembly to put aside their own religious beliefs, their own religious convictions, or even their own moral beliefs and moral convictions. We are not here to impose a belief system on any member of this society. We are here to act in the best interests of the whole of society and to protect against open discrimination against a minority who are governed by, or covered, by this term, protected characteristic. And I am very fearful, sir, that what we are talking about here, and I'm sure, many valid arguments that will be put forward about freedom of speech, freedom of belief, is missing the point. And the point is, we cannot allow open discrimination against anybody to creep in to our daily lives. And therefore, I urge members to really search their hearts, to really search their conscience, and go, would I be happy for my son or daughter who may be gay, they may be in the future in a same-sex relationship? Would I be happy going with them to visit the baker? We'll use that example because it keeps coming up. Going to visit the baker who's still, in business, who made the wedding cake for my wedding 5 years ago, with my son going, oh, it was such a brilliant cake. Here's my son and his partner. I'd love you to make a cake for them. And the man or woman who runs that business going, no, I refuse to do it because it's a same-sex marriage. But that person made a cake for my wedding, which I hasten to add was heterosexual. But the point is, are we prepared to allow that to happen? Are we really happy with that situation? I'm not. And I would hope that most sensible people who believe in love, tolerance, and forgiveness, right, which I believe to be the three cornerstones of living a Christian life. And remember, to be a Christian, to believe in God, you don't have to go to church. If you believe in those three things, then you cannot support, I believe, the acceptance of any form of clause that allows open discrimination. Thank you, sir.
Thank you, sir. I thought long and hard about how I should tone my remarks in this speech. I've been a supporter of LGBT rights my whole life, and when I was first elected to this assembly, I put my neck on the line by making same-sex marriage one of the first things that I sought to bring up in this chamber. And I think that I've shown quite a reasonable amount of restraint when faced with some of the arguments against in the years following that. We've been asked in this debate to keep things respectful. I believe that the way you show respect is by telling the truth, even if that truth is upsetting. And I warn members and the public that some of what I may have to say, some may find upsetting, but I will say it anyway because it's what I strongly believe. So let's be clear right from the very start of this debate that we are not debating a tolerance clause. We are debating an intolerance clause because that is exactly what it promotes. We are debating rolling back the anti-discrimination law, which we were already decades late in introducing to allow a minority within a minority to persecute a group which has dealt with quite enough persecution over the centuries. We are debating whether we say to gay people in our community that when it comes to them uniquely that they cannot expect the state to protect them as consumers from discrimination because of what they are, even though that protection applies to literally everybody else. I ask members to consider what kind of message this would send out about how we value gay and lesbian people in our society. Imagine if this clause replaced the word gay with the words black or Jewish. It would be absolutely unthinkable, yet somehow here we are anyway. There is no moral or legal justification for this clause whatsoever, and I am actually astounded that the scrutiny panel has brought it to this assembly on the flimsiest of grounds that some people out there want to have the right to discriminate, so we have to at least have the debate. The vast majority of decent islanders, and I'll add to that the vast majority of decent Christian islanders who I have spoken to, are staggered that this has even been brought up here, and I'm confident that this will be resoundingly defeated in this assembly today, and we will regret the consternation that this will have unnecessarily caused and the bad publicity for the island that this has already generated. Now, I don't want to get involved in name-calling, and we have been asked to be respectful in this debate, but I think we have to admit that it is difficult given what lies underneath this, really. You have to ask yourself the question, what would it be which would motivate somebody to want to go out of their way to treat gay people unfavourably? What is it that really makes somebody want to do that? And I'm afraid that there can only be one reason. It is the belief that there is something wrong with being gay. Irrespective of what inspires that belief, that deep down is what it really is about. If you didn't believe there was something wrong with being gay, why would you want to discriminate against them? And some are saying that it's because they don't want to be compelled to act against their conscience. Well, I don't know about you, but I always thought that your conscience was the thing inside you that tells you to be good to others and to feel bad when you're unkind to them. It doesn't tell you to treat others less favourably. That's the exact opposite of what your conscience is meant to do. And since the motivation for this is claimed to be religious, I ask, whatever happened to do unto others as you would have them do unto you? This clause promotes the exact opposite behaviour. So I think that deep down, for some of those who want this right to discriminate, it is because that they think that gay relationships are not equal, that their relationships are not valid. And some I've spoken to have actually said that they think gay relationships are unethical. Unethical is actually the word that has been used to me. And these people regret the advances that we've made in recent years, and what they want to do is hold on to whatever they can to legitimise their view that gay relationships are illegitimate. And I'm sorry if this upsets people, but I think this perspective is sinister, it's weird, and frankly, it's creepy. But what we're asked to do in this debate is have respect for the differences in opinion on this. That's the politically correct line in this argument that we're asked to take. And I don't actually agree with this, and I'm going to use a comparison to explain why. I'm thinking of another group in our society who are treated unfavourably, who are looked down upon by most people in society, and who would be limited in their job options because of how they are. I'm talking about flat earthers, people who believe the world is flat. Now, these people genuinely exist. They do exist out there. They have their organisations and societies, and presumably they hold that view sincerely and honestly. It must be very difficult being a flat earther, because nobody treats you seriously, you're ridiculed in almost every circle, and you would be prevented from sharing that perspective you have in schools and the like. That must be very sad and upsetting to be in that situation. But they're wrong. The world isn't flat, and we don't have a duty to respect that belief, nor do we have to tolerate it as some sort of legitimate perspective in intellectual discourse and accommodate it by carving all sorts of opt-outs for them. The view is wrong and it's harmful, and we do not legislate for them to be protected in this view. I see this as exactly the same. If you believe that there is something unnatural about being gay, you are wrong. If you believe that being gay is a choice, you are wrong. And if you believe that there is something unethical about gay relationships, you are wrong. And to those who haven't quite got the memo on this yet, I'm afraid that they're just going to have to get over it sooner or later. For their sake, I hope it is sooner rather than later. The right of gay people to live their lives and be happy comes above the right of people to discriminate, to try to impose their religious doctrine on others when they are just wrong. And there's a reason why I am so unequivocal about this point, and I think this is really important. There is a reason why I'm not prepared to say that we should tolerate these views about gay people, and it's this. Out there in our island, many of our constituents, people potentially of all ages, but some of them young, will right now be coming to terms with who they are. They'll be discovering that there's something different about the way they are. Some of them will probably be quite scared about coming out and will be struggling with that because they might have intolerant relatives who they believe will make their life hard. They might be worried about being treated unfairly or facing prejudice throughout their life. Of this group of people, a disproportionate amount of them will face mental health struggles at some point in their life because of this. Those people do not need this debate. They don't need this fixation on them and questions still raised about whether they're normal or not. I think the least that they should expect is that their politicians will work to make their lives better, to know that we accept them for who they are and we want them to thrive. They deserve to know that we are on their side and not on the side of people who want to treat them unfairly and make their lives more difficult. That is what this debate really is all about. And the sheer amount of energy that has gone into putting on a coordinated political campaign, all for the aim of enshrining discrimination in island life. Aren't there better things to be dedicating yourself to? This is actually what I find most depressing about all of this. Jersey has, as we know, appalling levels of poverty. And this Assembly, and again, members won't like hearing it, but this Assembly has regularly made decisions which were obviously going to exacerbate the problems of poverty. Where were these people then? Why were our email inboxes not packed to the brim, full of people motivated to say, no, we oppose this because of what we believe about how we believe in equality, about how we believe in loving our neighbours, and we believe in striving for a fairer society? What has motored a self-interested group who are more interested in protecting their club from being forced to join the 21st century than use their political weight for the betterment of the island? I think that is such a shame. And I hope that when this Assembly deals with this issue, as it will, that these people will have to provide services for gay people, and when forced to do so, they will very quickly realise that these people are completely ordinary, there's nothing wrong with them, and that experience will make them realise this, and in 50 years' time, we will look back on this and we will wonder, what was the fuss all about? I ask members to consign this intolerance clause to the scrap heap where it belongs. Thank you.
Deputy Kevin Lewis.
Thank you, sir. I wasn't going to speak on this debate, sir, but I'm prompted to speak. My colleague on the panel has had a momentary lapse in memory that whilst I will be supporting most of the amendments, I've made it abundantly clear to all panel members I will not be supporting the tolerance clause. I just need to clarify that. Thank you.
Comment Hudson second.
Sorry to trouble you, sir. I'm just a little bit confused because I'm hoping that this law is for same-sex people and everybody who wants to be happy. If it's a general law to cover everything, does that mean that Sherry law, whatever they call it, can be brought in and we can't do anything against that? Because that would alter my vote utterly and completely. This is purely for our community here and same-sex marriage, and that will, I want some reassurance that that law, if it does, and it is here, that if it was to be raised, and if we cannot object to it, then I'm going to have to think very hard about my next vote. So I need to know that if that law is brought here or somebody does contest the law, they are not going to be held discriminating against, please. Could the Attorney General help me with this one? Sorry, no, you can't help me with that one either. I'm getting this. What's going through this morning. I don't mean to be disrespectful, and I have sung at gay unions, and most of my friends are gay. I think it's something to do with the theatre, but they are, and I love it. No, it's not a laughing matter. They are fabulous, and they've supported me through a lot of the troubles that I've been through. I have gender reassignment people that I know and love. But this law is worrying me, and we're getting so deep that at the end of it, I feel like I'll eat a guide dog and a stick.
Contab, if there's a specific question you want to ask the Solicitor General, then please do so.
Yes, I would like to know if we're voting on this, is it purely for what we're discussing, or if someone was to bring in the share law, can I say I don't like it? Sorry, if somebody brings in the law, or if I object to it, am I being intolerant to their beliefs?
If you
please.
Object to what?
If I object to the Sharia law. No, I know this isn't Sharia law, but we are making a discrimination law come through, and I need to know if that can be implemented into what is being said.
Right. Okay. The Solicitor General will no doubt be able to answer that later on. Deputy Tadier.
Thanks, sir. So I want to speak to the Amendment 3 as it is. I think that's what we're discussing at the moment, so as being proposed by the Deputy Chief Minister, to do with the fairly narrow issue of religious premises. And clearly,
no, we're not on that.
We're not on that?
No.
Can you remind me, sir?
We're on the panel's amendment to its own amendment. Do you wish to speak on that or not?
So can I put my name back then? I won't speak at the moment, but I reserve the right to speak, if that's all right.
Right. Does any member wish to speak? Conrad St John.
Thank you, sir. Every time a law is made, someone, somewhere, loses a little bit of freedom. That's not my quote. It's a quote from somebody significantly more intelligent than myself. But I think it deserves being repeated. Every time a law is passed, someone, somewhere, loses some freedom. One could almost say that this assembly is here to keep reducing the freedom of people, because that's what we do, is create laws. I looked up the human rights law, read it through, and it all seemed quite reasonable. Every person has a human right to be treated equally. And I agree with that. Every person has a human right to obey their conscience and to follow a religion of their choice. And I agree with that. And there lies the difficulty, because that in itself is a contradiction. How can you follow your own conscience and treat everyone equally? And this is where creating laws has created contradictions and has resulted in everyone, every single member of society, losing a little bit of freedom. I hope nobody ever accuses me of being intolerant or in any way discriminatory. Because I hope I am not that type of person. And I do not intentionally, at any time, act in a discriminatory manner. I am delighted that at long last, a section of our community can enjoy the freedoms of getting married and living life as they wish. And I welcome that. Many years ago, sir, I remember watching television with my father, and Arthur Scargill was on. And this was at a time when the UK, and I was at school there, were having compulsory power cuts. Electricity was rationed. 4 hours a day of electricity was all you were allowed, because there was no coal to power the power stations and generate that electricity. And Arthur Scargill was being questioned. Why are you holding the country to ransom? I've got my rights, and I have a right to strike. My father stood up, pointed at the television, and walked out the room saying, and what about your responsibilities? And this is an extremely important action. And I liken it almost to Sir Isaac Newton. Every force has an equal and opposite reaction. If you have a human right, you have a human responsibility. And how might one define that responsibility? And I think the easiest way is love thy neighbour as thyself. Or put in a slightly different way, respect your neighbour as you wish to be respected yourself. Some years ago, and I can't remember the details and I haven't been able to find them, but a former constable of St Helier enforced that everybody walking in town should wear a shirt because men were walking around topless. Again, that was not a matter of intolerance towards men who'd just come off the beach. It was tolerance towards everyone else. Treat others as you would wish to be treated yourself. Don't impose yourself in a way that others might find offensive, whether it's wearing a t-shirt, whether it's something you do. We have a right to follow our conscience. And I think where we have intolerance is the way in which we put ourselves over. If the shopkeeper, which is the classic example, who's baking a cake, shouts out, "No, get out my shop," that behaviour can never be accepted in any form of society. But if he were to say, "Sorry, with respect, that does offend me," then he gets sued. But he should be allowed to say, "Sorry, I find that offensive, but would you see so-and-so?" Put him onto another store, shop. There is, of course, sir, a very dangerous side to this. What if the shopkeeper says, "Yeah, okay, I'll bake you a cake," and he fills the cake with pepper or chili, and then gets a brick thrown through his window? And we have a danger here of escalating friction within society. I was also taught, sir, when I was at school, because there was a big sign on the wall, you cannot learn or hear when you're talking. Thank you.
Deputy Norton. I'm sorry. I thought
Oh, sorry, sir. No, I wasn't finished. I was just...
I thought it was quite an abrupt end.
I was thanking those people who were taking notice of the notice that was on the wall when I was at school. I shall be supporting the so-called tolerance clause. And the reason for that is because the number of people who've contacted me, not by email, but have taken the trouble to come and talk to me, have asked me to do so. These people are ordinary, everyday folk. And as I said at the start of my speech, and I'll go back to it, we are here to decide who we are going to discriminate against. Because one guaranteed thing that's going to happen today is members of society will be discriminated against. And we, as an assembly, have a simple choice. Are we going to discriminate against one group, or are we going to discriminate against another who follow their conscience? And that is the simple choice that we have today. And I shall be supporting those with a conscience. And I'd ask other members to think about it and to do the same. Thank you, sir.
Sir, could I ask a question of the SG which relates to that speech?
You are able to ask a question of the Solicitor General without making a speech, and he will log it with the other questions and no doubt speak later.
I just wanted to know, because some members are discussing freedom of thought and belief and freedom of speech. Does the proposed law prohibit anybody from holding any beliefs or from expressing them respectfully whilst still providing a service? So the example that the Connotab just gave of could a business owner say, I respectfully disagree with the practice of equal marriage, but I'm still going to provide you with the wedding cake. Is that still allowed under the laws as they're coming in?
Deputy Norton.
So I have a question for the Attorney General, if that's all right. I don't need it answered straight away, but to add to the list.
Right.
I'm sure he'll have to answer them at some point, the Solicitor General. It's just to say that if the Corporate Services Scrutiny Panel are successful in their amendment, it seems to be couched in so far as it would only apply to those who turn away business on religious grounds because of religious beliefs. But of course, how do we know, how would we know under the law whether or not somebody has those convictions as a religious belief or as a non-religious moral belief? And could they legitimately, is there a difference under the law? And could they not simply say this is a religious belief when it actually might just be a moral belief?
Are you ready to deal with all the questions now, Solicitor General?
I can deal, I think, with most of them, sir.
Well.
Sir, as regards Deputy Martin's question in relation to employers and employees, as I understood that, was there anything in the law which would protect an employee from providing goods or services in relation to a same-sex or an acquired gender marriage? So the answer to that is if the tolerance clause is not passed, or the conscience clause is not passed by the Assembly today. So as regards any public law right of an employee in those circumstances, they would not be protected because as the Attorney General's advice has dealt with, in fact, in paragraph 21, for the purposes of the discrimination law of 2013, that law looks at an employer and an employee differently. So the prohibited conduct, which is in Article 22 of the discrimination law as regards not discriminating on the grounds of goods and services is directed at a person which is a natural or a legal person. So that might be a sole trader, or it might be a company, or it might be a partnership. But when one looks at it in a employer and employee relationship, that the Article 22 is biting on the contractual relationship as regards the provision of goods and services or facilities. It's not really looking at it from the point of view of employer and employee. So the short answer to Deputy Martin's question is that there wouldn't be a protection for an employee who is given a lawful instruction by their employer to provide goods and services, it might be haircuts, it might be cakes, to a same-sex or an acquired gender marriage. Now that's the public law position. There might be some private law rights which have been contractually agreed as between employer and employee. So it would be open to an employer to have a policy or terms expressly written into terms and conditions of the contract of employment as regards what they do in relation to same-sex or acquired gender marriages. So that there is a potential protection there, but that would be a private contractual matter as between employer and employee. So as regards the Constable of St Saviour's question in relation to Sharia law, so the law that we're debating today, sir, has, in my respectful submission, nothing to do with the introduction of Sharia law in Jersey. Sharia law is a much wider concept than just marriage, and this law is dealing with marriage and same-sex acquired gender marriage and various other provisions as regards requirements for registering marriage and so on. So this law has got nothing to do with the introduction of Sharia law in Jersey, but if it assists an Islamic official who is officiating at a Islamic ceremony of marriage would be protected under the quadruple lock provisions which are in the draft law. I'm just looking at Deputy Dublay's question, which was in relation to whether or not it would be open to a person who is providing goods and services to, say, where they're approached by a same-sex or acquired gender couple who are getting married, whether it would be open to them to say, well, I respectfully disagree with same-sex or acquired gender marriage, but I will go ahead and provide the services nevertheless. In my view, there is nothing to stop a supplier of goods and services to say that, providing, of course, it is couched in respectful language and not a way that is seen as in some way abusive or could amount to cause offence. In relation to Deputy Tadier's question, I would respectfully ask him to repeat the question because I didn't get a note of it.
Thank you, sir. I'm happy to do that. So essentially it relates to, first of all, the effective interpretation of this amendment were it to go through. Is it the case that this would only apply to people with a religious conscientious objection? And if that were the case, what's one to stop substituting someone who has a moral obligation but not necessarily a religious conviction and all the potential complications that arise from that?
And I thought it was how do you prove it? Wasn't that your question as well?
Yeah, essentially, sir. Yeah, that's right. And that.
Yes, sir. The Corporate Services Scrutiny Panel's amendment is couched in terms as referring to religious belief, conviction. So if it were to come before a court as to deciding whether or not the refusal to provide goods or services, it would be a matter of fact for the court to decide on the basis of evidence as to whether or not the objection was based on religious conviction or for some other reason. And so it would be a question for the court to decide essentially what is a religion. And that is a matter of fact for the court to determine. There was a recent case in the United Kingdom Supreme Court where a definition was attempted of what is a religion. And that may well be of assistance to a Jersey court faced with similar circumstances. But it is essentially a question of fact to be decided, as this is would be a civil matter, on the balance of probabilities. I hope that assists.
And so supplementary, so when one has defined a list of what a valid religion is, how does one decide whether the person who may have infringed this law is an adherent of that religion, given the fact that one, as my colleague in front says, one doesn't have to go to church to be a Christian?
Well, the burden would be on that person seeking to establish that they were motivated by a religious conviction. And they would have to bring evidence concerning the way that they conduct their lives in order to satisfy the court as to whether or not they were in fact motivated by religious convictions or for some other reasons. And the person would very likely have to give evidence in the witness box and be cross-examined by the other party in order to establish, as a matter of fact, whether that particular defence is made out.
Well, sorry, is that a further question, Deputy Martin, for the solicitor?
No, sorry, sir, I was just waiting for this.
Yeah,
when
Deputy Norton.
Are you sure, sir?
Well, yes, I think I've got the question.
Thank you, sir. It's been a funny old week because of the amount of people that have engaged with us by one form or another. Unusual, I think. And I have been both saddened and outraged by some of the communications that I've received. Respectfully done in some cases, not respectfully in others, on both sides of this argument. And some of those people have said, yes, but I do have nothing against anybody who's gay, but we really shouldn't give them any rights, should we? I don't agree with them being married. Not that I'm discriminating against them, of course. So I have been outraged at times. I have been saddened at times. I did see on social media sight of a letter from the Jersey Evangelical Alliance with their recommendations, thankfully, all of which were not brought forward by the scrutiny panel and their amendment. And I was certainly outraged by some of their suggestions, which ranged into employment and the right not to be able to employ somebody who is gay, which I was absolutely astonished at. I was also heartened and uplifted by some of the messages and communication that I got, because they contained love, compassion, caring, all of the things that you would expect to come from a decent society, be it Christian or otherwise. Overall, I was heartened by the interest and the engagement, as I mentioned. But what of this amendment, and what of the damage that it has caused? On the outset of where we are right now, nobody's winning. Nobody will win, and the damage will go to everyone. The amount of times I've heard people say, well, if that's the way the church feels, you know what the church can do. If that's the way Christians believe and behave, then I don't want to be one. And I'm saddened by that. because there is damage to our churches because of what's been said in the last week. And then there's the concerns this week from those within our LGBT community who have had really genuine concerns that they're being singled out, that they're being made the exception. And they've had those concerns all week, and they've been worried, deep concerns. And so they've had damage too. And then there's our island, as an island. And the damage to our island from those who have heard that we're even considering debating this. The amount of emails, the amount of social media, the amount of personal messages that I've had from people across the world who have said to me, what on earth are you thinking of? And I know that Deputy Le Fondry will say it's right that we have this debate. And like the good Connétable of St Saviour only a couple of days ago, I think what I have to do is look at the glass half full, not half empty, and look at the positives that can come from this debate and from, hopefully, this decision today. And I emphasise today. We can repair some of that damage. In fact, we can repair pretty much all of that damage if we really want to. Let a message go out that we will not stand with discrimination. Let a message go out that we just won't stand for it. That we believe in an inclusive community of equality. It's a pleasure to have followed speeches that covered much of what I was going to say from Deputy Brie, Deputy Mezek, and others. Let's look for some tolerance, not some intolerance. Let's look for diversity, not to be divided. And let's look for acceptance, not for exceptions. So I implore members to throw out this so-called, ironically called, tolerance clause, because it is ironic. It's nothing but intolerance. And not to accept it. And let's get back to repairing and showing the rest of the world what kind of community we really are. Thank you.
Deputy Sutherland.
Thank you, sir. And I rise to speak feeling rather sorry for Deputy Fondry, because he's fallen into what I think is one of the classic traps of scrutiny. Now, when I'm running scrutiny, if we can't agree on something, we go back to it, necessarily, time and time again, until we find a form of words that we can agree on. And sometimes that's a mere matter of saying, have we got the evidence to say we must do this, or they should do this, or we may do this. And we'll go back to it, find the form of words that everybody's happy with, and then we know, and the key question is, and do we have the right level of evidence to back this up? And if the answer is yes, and we can agree something, that's fine, we go ahead. We don't bring something, I've never brought something, where the panel has been split. If it's split, it suggests you haven't done enough work on it. And the key to decent scrutiny work is always, in my case, take the opposition head off and put the scrutiny head on, where I'm solely interested in evidence. Now, poor old Deputy Le Fondry, it's not just had to take off his opposition head, but he's had to look around his deeply held convictions, his own belief system, I think, with the result that actually I don't believe that this proposition should be coming with the backing of a scrutiny panel. It shouldn't be a scrutiny agenda, it should be a backbench agenda where Deputy Le Fondry is pursuing his own personal agenda and it should be in his name and not in the name of scrutiny, because I think that ultimately brings scrutiny into some disrespect. And I felt sorry for him again as he was introducing this with his continued reference to canon law. And for me, that made me think, well, hang on a minute. At one stage, when was it? 400 years ago? 500 years ago? The church wrote the law. It was the law. Things have changed, Deputy Le Fondre. The church no longer writes the law. We write the law. And we have a discrimination law to protect people from what I would call this, it's called a tolerance clause. It's actually a charter for bigotry, is what it is. And having said that, I was thinking, well, what's the analogy that I need? What did the church used to do that it no longer does because it's become more civilized, more humane? There's all sorts of things we could have picked on. Its treatment of women, still lacking in some cases. We haven't had a woman pope yet, I'm afraid. Although no doubt we will at some stage in the future. And I'm just about to get on to burning. And it used to be that the Catholics used to regularly burn the Church of England people and vice versa. And for people like me, 400, 500 years ago, stuck in the middle as a devout atheist, I would be likely to be on both of them, both of the funeral pyres. And they'd probably still be fighting over it. That's a Catholic funeral pyre. No, it's not. Church of England. Thankfully, we've moved on from those days, and I'm not threatened by being burned at the stake. And then I thought, yes, but until 50, 60 years ago, gay people could feel exactly that threatened. They were threatened. They would be beaten up on the street. They would be attacked. They would be condemned, in some cases, by the church. Again, we've moved on. And I found it deeply ironic that the proposer, Deputy Le Fondre, kept referring to some form of retraining, as if that was the threat, the Mao-style retraining that we're going to have to do, and that might take place in order to resolve this issue. The fact is, what we have here is, again, an argument that was explored hundreds of years ago. It's Swiftian, isn't it? What we're in is an argument, an intense argument, between the big enders and the little enders. It doesn't really matter. But what does matter is that this body takes hold of the law and treats its citizens, all of them, in as fair a way as possible. This tolerance clause is an intolerance clause. It does the exact opposite.
Deputy Martin.
Thank you, sir. And I thank the Solicitor General for his advice, which he sort of confirmed the way I'd read this law. As many have said, we've all been contacted across the last few days, weeks, about this so-called tolerance law. And the more I've read from the people who are urging me to support, it was defending the right of the shopmaker, the wedding dress, you know, where you get your wedding dress, and the person who owns that company. Now, I listened again to Deputy Le Fondre, and he said it's small employers who absolutely do not want to give their service because it's to do with a same-sex marriage. And then I read the words of the Attorney General, and this amendment just gets worse and worse and worse. Because I have to read out to you part 22. It says, the effect of these provisions, this is the Attorney General words, sir, if I may, of the 2013 law is to place the compliance obligation of non-discrimination on the employer and not, in most cases, the employee. The effect of the panel's draft Article 7A of 2001 law and new Article 24A of the 2013 law is to remove the compulsion on the provider of the service not to discriminate. Now, this is the bit that really, this law in itself divides. Having removed the compulsion on the service provider, the owner, that's my word, sir, the provider, if we pass this today, can lawfully instruct their employee to provide or not provide the service, which would amount to participating in same-sex marriage. So this goes even worse. This makes it even worse, sir. So you go back to the simple argument of the Constable of St John's, where the same-sex person goes to the baker and says, I want a cake. It doesn't matter which way the owner of the cake shop says he's not going to provide that cake. It doesn't matter if he says it politely, he says it rudely. You pass this law today, he can say to any of his employees, I'm not baking this cake. Lawfully, I'm not. But you are. Now, that person, as Deputy Leader Fondry keeps telling us, and I'll quote because he said it about 5 times and I wrote it down for work, free speech must apply to all those who hold strong religious beliefs. But I'm adding, but not if you're the employee of these companies. A small hairdresser's who's going to provide the hair and beauty on the morning of the wedding. The coach driver who's going to take from the venue to Gorey to back. And he says on the day, oh, I phoned the boss, sir. Boss, I can't drive these people. I've just found out it's a same-sex wedding. The employer, this one could be, he might agree with the tolerance clause, he might not. He's the employer and he's taking the money. So he's saying to the employee, oh, yes, you are. Well, it's only going to end one way. And the Solicitor General has already said there's nothing in our other law. Roll up to Jack's and say, well, I've been providing this service for these people, the hairdressers, for the last 20 years. But on this morning, I walk in and I find out it's 2 women getting married. And I'm not. So I tell my employer, I'm not. And she says you are, or he says you are. Because if we pass this law, are making that lawful. So when maybe they are not all religious who have wrote to us and said, please, 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 support this intolerance law, because you can't compel people to do what they don't want to do because of their strongly held beliefs and, but they're forgetting the majority of the society who are the employee. I can't believe this law was passed. It was able to be constructed how it is with the other laws that I've fought for in the many years. I can look around the many years of, been here quite a few years, the employment law. Now the discrimination. I can't believe that this then even gets smaller. But then Deputy Fondry's interpretation is the small. What if we find out tomorrow, we pass this law in Jersey, that one of the massive chains, I won't say a name, but say a big chemist chain or a big provider, and they found the boss of that company wanted to uptake our tolerance law. So everybody in that company cannot provide a service. The way I read this, sir, and I literally, I bow to the Solicitor General, they could then instruct their employee in a massive chain, and wouldn't that look lovely? Doesn't work anywhere else, but in Jersey, this big chain, because the main man or woman or the owner doesn't agree or holds these strong religious beliefs against same-sex marriage, is now told all the employees in that particular branch in Jersey, only Jersey. I can see that on every national newspaper, and rightly so. And that is this is the law. It's divisive in itself. It's not acceptable. But when you make I call it a rich man's discrimination law, the owner of a business law, have no consideration for what the employee must do, absolutely can compel. So it is even worse that the person can say no, but they might say to the manager of their business. Now, I know I'm re-emphasising this because this is how bad the law is. They may walk away, they may go away for the weekend, and they'll leave everything in charge to the manager, who may still hold them same beliefs. It could be a family business. The owner could be your brother. But they're covered by the law if you bring this in, and the manager is not. It's absolutely discrimination in the law as well. And I, for one, sir, when I read it, and actually it's not my words, this is what the Corporate Services Panel produced to states members. This does not, and a big capital not, extend to employees of organisations. So you're an employee and you have these beliefs. It does not make sense to me, sir. I mean, I could say much more, and others have covered other points, but I cannot believe that we would allow something to go through where we would let somebody opt out, the employer, to then compel, and the word is compel, their employees to do something that they may not. I say I disagree, sir, with the whole of it. But when you look at where the law could go, it is absolutely. The Solicitor General said when he was answering my question, it could be covered. So I just want to cover this, sir. It could be covered by an employer-employee agreement that you know. But he's coming from the point, I think, that the employer would be of the, I am going to opt out. What if the employees are the people who have the strong beliefs, but the employer doesn't? The employer's fine, will, as Deputy Bree says, is providing a service for weddings, and he will provide that service to anyone. You are not going to then get that employer to give you a right-out clause. It just wouldn't work. And why should it? So, I mean, this tolerance law clause, to me, makes this worse. But when you actually read what the difference is between the business owner and the people they're employing with the same consciences, the same rights, it doesn't work. So, to me, sir, I'm not going to support it. I wouldn't support it anyway, but when you drill down, it's a divisive, discriminatory law within a divisive, discriminatory law to give a few rights to a few people. For what reason, I have no idea. Thank you, sir.
On the Deputy St. Warren.
Thank you, sir. I think the first thing to say is, oh, how I wish, and I think many of us would wish we would have had a calmer debate with much more time to look at these issues. It's a matter of regret to me that the scrutiny panel could only begin its work on the 25th of November, and this debate has to take place very rapidly after that, because this is an issue which is being discussed in many jurisdictions, and it is an issue which affects large numbers of people, and it's highly complex and difficult. And what it seems we have seen is that there was an initial consultation process, but then the law drafting work began in earnest and seemed to take an age. And that was all done within departmental walls, and then suddenly the final draft is released. And then people have to respond to what has been fixed and finalised and lodged. Wouldn't it have been better if scrutiny and the society in general could have got involved sooner to talk about how we make this balance, how we try and accommodate, to what extent could we accommodate differing views in the law drafting process. And as a general point, this just shows, I believe, how we must make better our legislative scrutiny. And the way we bring these laws of great import. But we're in this situation where tensions are high, and the risk is there's a lot of misunderstanding around, and I think there's a feeling that the church, or some members of churches, are being extremist and unnecessarily alarmist, indeed rather bonkers. Why are they insisting on these antiquated rights in the view of some? But I think we must ask, why might a person of faith not wish to participate in a same-sex marriage out of conviction? And I think it's because a person of faith has chosen a framework in which they choose to live their lives. Other people have called it a belief system. But it's not their own, it's nothing they have fabricated for themselves. In the Christian context, it's a framework of belief that has endured for 20 centuries. It's shared with millions of people who are alive today, and others who have lived and throughout history in the past, and moreover is shared in every part of the globe. And that framework of belief is put together by biblical teaching and theology, but their faith is also a personal experience. It is not just adherence to a set of rules which you are bound to follow. It is a choice, it is a personal experience. And those people of faith have recognized a spiritual dimension in life, and they have chosen to respond to that spiritual dimension, their choice. But a choice that has been built upon, that has been available, that has been grown over centuries. And then it has to be acknowledged in the Christian church there are differences, and those differences are often very difficult to work through. And as a general rule, I think, and in the spirit of humility, the Christian denominations or groupings recognize that no one grouping has the complete, entire revelation of all things spiritual. We have to listen to each other, we have to learn, and recognize that sometimes faith can be a journey. And it can be a journey for the churches as institutions as well as individuals who profess a faith. And that is the reason why some churches and some individuals are able to accept same-sex marriage and others are not able to. But all will hold their faith sincerely, because their testimony is that their faith has changed their lives and their framework of belief guides their daily living. And in the case of Christian marriage, it is very often fundamental to many believers, because it is the Bible that gives directly Christ's teaching on marriage. And marriage, of course, is the most intimate and profound and long-lasting relationship. Many Christians will see it as a reflection of God's own relationship with humankind. And I believe most Christians will accept that same-sex couples should be free to live within loving, positive relationships. But for some people of faith, calling those relationships marriage does genuinely hurt the values that they hold deeply. And the situation has arisen that for centuries, the state's view, the state's definition of marriage aligned with the religious and the Christian interpretation of marriage. Very recently, that has diverged, so that now the states, our states, legislatures in many other places are saying that marriage goes beyond the purely Christian view of marriage. And of course, legislatures, civil society is free to do that, but let's recognize that that has only recently happened. And let us recognize that people who hold sincere convictions can find that difficult to move at the same sort of speed that others have found they are capable of, and to move in a way that is contrary to their religious belief. So it might be said, well, fine, hold your religious beliefs, but keep that view in private. And the difficulty is here, Christians and people of faith are part of society, and they are engaging, and many of them are providing a service. But should they be asked to leave their faith behind the door of their homes? But I think the difficulty is a faith, if it is to be real, has got to pervade all aspects of their life. The Solicitor General, in responding just now, said if you wanted to prove a faith, you would have to bring forward evidence of how you live. So their faith would pervade the jobs they do, the businesses they run, and the freedom of religion, which is granted by the European Court of Human Rights or the European Convention, it's not limited to a freedom to hold a belief, but also the freedom to live your life according to that belief. And so what we're discussing here today is certain clauses which are limited in application because they might allow certain people of faith to choose to not participate in a marriage, limited to that, because that marriage genuinely hurts their sincere convictions. And the rationale is that perhaps those people should not be compelled to provide that service in a way that requires them to act in violation of their deeply held convictions. And that can be seen, and I understand how that can be seen as discrimination against a same-sex couple. But it's easy to rush to that view, I think, or a view that it is homophobic. And I think we should consider, why are these people, why would they choose to do that? Because it seems to me the discrimination that exists is not directed towards the people, it is instead they are seeking to hold to the values which guide their lives. And there is a conflict there, because the people they are engaging with hold other values. What are we to do? Must we enforce a uniformity? Or is there a way of holding in tension differing views, genuine views, but differing? And they are not the sort of views that might be held by flat earthers. They are not views that can be rejected as quirky or off-beam or unreasonable. And in fact, they're the doctrine of the established church. And they're the doctrine of other churches. But they've been widely accepted as the normal views of right-thinking people for generations, up to very recent times. And they are still views that are shared by millions of people worldwide, and indeed across religions. So, for those reasons, I think declining to participate in a same-sex marriage can't be well compared with, say, racial discrimination. Because, no, it can't be. Because there is no recognized belief system that advocates discrimination on the grounds of race. They are not. You think of the Islamic world, which they are British people who are Muslims, they are African people who are Muslims. As far as I'm aware, and I'm not a theologian and I'm no great expert on worldwide religions, but you can adhere to a religion wherever you live. And there's no recent large body of opinion which says that there should be discrimination on the grounds of race. There are some things that are settled. But when it comes to same-sex marriage, let's quite frankly admit that it is controversial, and it is the law of the land that is accepted. But to require people in their conscience to accept it is another thing. And if there is a view that people of faith just need to wake up to the modern world, well, consider that it's only, I think, in the last 6 or 7 years that same-sex marriage has been on the mainstream agenda. And it was David Cameron, wasn't it, who suddenly, out of the blue, one day announced that this was going to be the policy that his government wanted to pursue. That's fine. He can do that. But there was no public debate about it. There was no doubt debate within a particular community. But there wasn't a public debate. That occurred afterwards as the legislation was being put forward. So if there's a view that people of faith have got to be ready to abandon their belief and join a mainstream, wouldn't it even be reasonable to give those people time to make a change in their conscience, a change from an established position of centuries of societal thinking? Instead, there seems to be an insistence that they must pulverize their conscience in order that we can all move at once to new ways of thinking. So, would it be an act of discrimination to decline to participate in same-sex marriages? Well, of course it would be if we choose to legislate that way. But what is the true nature, what is being asked for here? And what is being asked for is the facility to be able to differ from your fellow citizens. And in a free society, surely that must be right, to express those differing views. And surely we must all be able to respect difference in our common life. So we should value and we should protect the freedoms of people to say things and to act according to their beliefs, even if they challenge us or even if they make us uncomfortable. And I'm reminded of Deputy Tadier's speech yesterday about needing to hear things that are uncomfortable sometimes, but valuing people's right and freedom to hold those views and act accordingly. And isn't that the purpose of systems of law and government, to take account of tensions between different worldviews? and attempt to arrive at solutions that accept differences in society and still allow society to function well. And what may be happening now is that a law may be compelling unwilling people to participate in a procedure which can be seen as one value system dictating to another how they can operate. And isn't it right we should strive to achieve some sort of balance, or call it tolerance? So it's not about agreeing or even accepting the views of people of faith, but ensuring there is space for those views. So if the choice is made to enforce conformity, that we must all accept the idea of same-sex marriage and compel people to act in a way which violates sincerely held views, we can do that. But I think we would be weaker as a society if we did that. Surely we would be a stronger and a freer society if we could acknowledge there are competing views. Competing views of what good is, what the best way for us to live our lives. And that's why I can't, and I would certainly not, as Deputy Southern has done, say this discussion should never have been brought. It is wrong for scrutiny to highlight the fact that there are differing views and people are upset at what a law is proposing. That should never be the case. We should be free to discuss uncomfortable views. So thank you to the scrutiny panel for allowing us to debate this. But the amendment is, it seems to me, that the best that we have in the woefully short time that's available. There perhaps could have been other ways of thinking this through, of proceeding with this debate. There might have been other solutions, and I think there have been. Deputy Martin has spoken about the employment situation. Well, that hasn't been considered in the draft law or by scrutiny, it seems. Scrutiny certainly had not had time to think about that. But it could have been thought of. There are perhaps issues surrounding employment. And this is a very limited amendment. It is perhaps an indication, if we were to support it, that this Assembly recognises that there is room for difference and that we must be able to accommodate people who wish to act reasonably according to their belief. Rather than insisting that we all move to share the same worldview, or else we must all suffer the consequences. And I won't be too much longer, I'm going to the end, but I don't want our society in this lovely island, a peaceful, tolerant, liberal democracy, to move to a situation where people will feel that they are pushed out of public life unless they sign up to a uniformity, that they have to believe this, they have to approve the other, they have to act as a certain way, otherwise you can't take your place in public life. So I would hope there would be some way, and therefore I'm going to support this amendment because it's frankly the best that's come up in the time. But if members believe this amendment should not be approved, then I hope they will inform the Assembly what protection would they want to give to people who can't make that change because of sincere convictions. I understand in the UK faith is featured in the Equality Act. There are some protections, however, inadequate. The scrutiny report talks about the principle of reasonable accommodation of faith, which has been accepted and incorporated as a principle in some legislatures. But there's been, it seems, no time to consider that. And I don't know much about it. And I regret I haven't allowed myself time to look up how we might do things differently. But what protection can we give for sincerely held religious views? And if members don't believe there should be any protection at all for the way people of faith might wish to live their lives, then I hope they will say precisely why not give that protection and whether the consequences of that matter to them. Thank you, sir.
No, Senator, I was wondering whether you would call for the adjournment. Senator Joseph is next in line. I was wondering.
He just indicated he had 2 minutes to speak, but I don't know whether that's whether he's possible, whether he's capable of that.
You were going to call me. I was going to propose the adjournment, sir, and I was just going to say two things before that. But if you, I am next to speak, am I?
You are next to speak.
Okay, fine. And I'll propose the adjournment.
The adjournment's proposed. We'll reconvene at 2:15 this afternoon.